All right. All right, we're back on the record on State versus Lloyd. He's present in the courtroom along with his attorneys. State Attorney's Office is present. You all will be prepared to move this trial tomorrow morning. We're going to a felony courtroom. I've had it with the elevator on this floor. So I'll give you the courtroom as soon as I know. Freaking hell. All right, let's wait for a minute to get that juror up. Our plans to start early, of course, have failed miserably. Is Derek out of that elevator? Do we know? Or is he still stuck? Is he out?
Yeah, he's out.
Do we have the 11 jurors that were asked to come at 1 o'clock? Do we know? I thought we had some that were coming at 1, yeah. Because I feel bad because we asked them to come at 1 and then haven't called them in here. So, Jesus. All right, I'll explain it to them when they get in. Thanks. Yes, ma'am.
All right, that is tomorrow morning, before 19A.
We're ready. Jury's out ready? All right now, what you said, all right now. I got it. Ladies and gentlemen, would you please raise your right hand, face the clerk to be sworn and answer out loudly.
Swear to be solemnly swear or affirm that you will answer truthfully all questions asked of you as potential jurors to help you God.
Have a seat, folks. 227. Okay, great. All right, good afternoon, folks. First of all, welcome back. I know some of you came in early at our request, and I have to apologize. Frankly, what we had was an elevator issue that prevented us from getting into the courtroom, and that's why we kept you waiting. We do apologize for that. I do appreciate everyone showing up early. We're trying to give the case the time and attention it needs while at the same time moving this along so you can be released as soon as we can. So you're here for the second day of jury selection. As I told you, this is a capital case. It is a death penalty case, meaning death is a possible sentence in this case. So what we're doing today is I'm going to give you some more information about the case. I'm going to give you some instructions and explain to you a little bit more about the case. The information you're being given is necessary for us to be able to talk to you today and have individual conversations with you. Once I've instructed you, you're going to go back in the jury room. We're going to bring you out here one at a time to answer questions. As I said, we're going to try and get you through here as quickly as possible today. As I told you all, this is a capital case, and what that means is if certain things happen, the death penalty becomes a possibility in this case. Because we need to know that you can do your job if it becomes the death penalty becomes an option in the case, we have to go through this process. So I'm going to explain a little bit more to you about what the charges are, what the process is, and the whole goal of this is to find out whether or not you all can do your jobs as jurors in this type of case, should it become necessary. I'm going to start by telling you that Mr. Lloyd has been charged by indictment. This is the indictment. It's a copy of it. Indictment, as you can see, it's pieces of paper that tell Mr. Lloyd what he's charged with. You have to tell people what you're accusing them of doing, what crimes you're charging them with. We do it this way, by indictment. Indictments are not evidence of guilt. You can't use them as evidence of guilt. The other way of saying that is just because somebody's been charged with a crime doesn't mean you can assume that they're guilty of it. In fact, Florida law requires the exact opposite, which is that you be able to presume him innocent until and if the state proves he's guilty. He has been charged in this case with first-degree murder with a firearm of a law enforcement officer, attempted first-degree murder with a firearm of a law enforcement officer, aggravated assault with a deadly weapon, carjacking with a firearm, possession of a firearm by a convicted felon. It is the first count, first-degree murder of a law enforcement officer, that is what we call the capital count. That is the only count that if he's convicted of it, the death penalty becomes a possible sentence in this case. So let me start by explaining to you all how these cases are tried. There's two phases to these cases. The first phase is what we call the guilt phase. The guilt phase is where the jury determines whether or not Mr. Lloyd is guilty of the charges against him. So your job as a juror in the guilt phase is you're going to sit in these chairs, these jury chairs. You're going to listen to the evidence that is presented to you. Evidence comes in several forms in trials. Witnesses will be testifying. They sit right next to me in this little box right here so that you can see them and hear them. The attorneys have the right to examine and cross-examine them, which is a fancy way of telling you they have the right to ask them questions. All right. There's also physical evidence that may be introduced, videos, photographs, documents. Jurors must be able to see them, understand them, and hear them. At the end of the presentation of all of the evidence in the guilt phase of the proceedings, when you're trying to determine whether or not someone is guilty, I'm going to give you the jury instructions. I'm going to read them to you, and I'm going to give them to you in writing. Jury instructions are the law that the jury is required to follow in the case. It's not optional, it's a requirement. It is the law. The jury determines what the facts are. The court tells you what the law is. You all take the facts and apply it to the law and reach verdicts. All right? The guilt phase of capital cases is conducted the same way as all criminal cases. You're going to be asked to return a verdict of guilty or not guilty on all the counts. Your verdict must be unanimous on all of the counts, meaning each juror must agree on each count either to acquit or convict. The burden of proof on the state is the same as in all other criminal cases. It is proof beyond a reasonable doubt. The instruction you receive on reasonable doubt will be identical to the instruction that is given in all criminal cases. The burden on the state is not higher because of the possible penalty. When you're deciding guilt in phase one of the case, you will be instructed to ignore the possible sentence for this phase. In other words, we ask jurors to decide whether a defendant is guilty or not on the charges, including first-degree murder, on their own merits, and you will be told to disregard the possible consequences of your verdict. The only question you're to answer during the guilt phase is whether the defendant is guilty of murder in the first degree, as well as the other offenses charged, or guilty of a lesser included offense, or not guilty. And we expect you to carefully consider the facts before you reach a decision. The fact that a defendant might face a death penalty is to play no part at that stage of the proceedings. If and only if the jury returns a verdict of murder in the first degree, the jury then reconvenes for phase two of the trial, which is for the purpose of rendering a verdict as to which sentence, death or life imprisonment without the possibility of parole, should be returned. That is what is known as the penalty phase. If that happens, I will be giving you the instructions and rules for penalty phases in detail. Today, I'm just giving you an overview because it's really all you need for the purpose of answering questions today. Because the death penalty is reserved in Florida for one class of crimes only, and that is murder in the first degree, the legislature has created special rules for juries to consider in reaching a verdict in the penalty phase. The legislature recognizes that not all first-degree murder cases deserve the death penalty, so they created a list of circumstances which juries are to consider in reaching a verdict in a death penalty case. The circumstances the prosecution relies upon are called aggravating factors. The ones the defense relies upon are called mitigating factors. The aggravating factors are required, the state is required to prove them beyond and to the exclusion of a reasonable doubt, and they are limited to 16 in number. There's 16 of them, and they're statutory. The mitigating factors do not need to be proven beyond a reasonable doubt. They only need to be proved by the greater weight of the evidence, which is a lesser standard. Mitigating circumstances are not limited by statute, and they can include anything that is related to the defendant's background, character, or the circumstances surrounding the offense. They are offered as a basis for a verdict of a sentence of life in prison without the possibility of parole. Life in prison without parole in the state of Florida means exactly that. The defendant will die in prison. We do not have parole in the state of Florida. Now, before you may vote that the court impose a sentence of death, the state must prove at least one aggravating factor by or beyond a reasonable doubt. They can prove more, but at least one has to be proven beyond a reasonable doubt. If the state does not prove at least one aggravator beyond a reasonable doubt, the only possible sentence is life without the possibility of parole. The vote on that must be unanimous. Every juror must agree they've proven at least one aggravating factor before you can go on to the next phase. So what the penalty phase looks like is another trial. The state's going to put on evidence of aggravators. The defense is going to put on evidence of mitigators. Once all that evidence is presented, I'm going to give you the jury instructions, the law that needs to be followed in this phase of the proceedings. You're going to go back in that jury room with your fellow jurors, the same jury room you've been in now. And what you're going to do is you're going to weigh the aggravating factors and the mitigating factors. Now, the weighing process is not mathematical, it's not mechanical. You don't add up the aggravators, add up the mitigators, and say, well, this side has more, so they win. That's not how it's done. Weighing means that each juror individually has to assign to each aggravator and mitigator the importance, the weight that they give it. And you may differ in your opinions on this, all right? One of you may find an aggravator to be very important to your decision. Someone else may say, that doesn't really factor into my decision. Same thing with the mitigators. You may find one critical to making your decision. There's others you may say, this doesn't really sway me one way or another. I don't think this is important. It's up to each one of you, but you have to weigh each aggravator and mitigator. When you're done with all of that, then you're going to take a vote on this. Now, regardless of your findings in this respect, you are never compelled nor required to vote for a sentence of death. The final step in this phase of the trial is for each of you to determine whether the defendant should be sentenced to life imprisonment without the possibility of parole or death. The court may not impose a sentence of death unless each juror individually finds the defendant should be sentenced to death. The vote for death must be unanimous. The vote for life does not need to be unanimous, all right? Even when death is a possible sentence, each juror must independently decide whether life imprisonment without the possibility of parole or death should be imposed. Regardless of your prior findings, the law never compels nor requires any juror to determine the defendant should be sentenced to death. Any single juror has the right to vote for a sentence of life imprisonment without the possibility of parole. If after deliberating, the jury unanimously agrees that the appropriate sentence is death, then your verdict may be for a sentence of death. If the jury does not unanimously agree that the appropriate sentence is death, then your verdict must be for a sentence of life imprisonment without the possibility of parole. As I told you, this is a very broad outline of how these penalty phases are conducted. If you ended up in one, you would get detailed instructions on all of this. Let me also say one other thing. The fact that I'm talking about the death penalty is not to be taken by you as any indication one way or another as to whether or not this is a case which justifies a death penalty. I don't know that, and you don't know that. I'm only discussing that because it's a possibility. It doesn't presuppose anything. We just need you to be ready to do it if you have to do it, so we need to find out if you can go through this process. And let me explain something else about the process. The penalty phase requires an open mind, meaning you can't be sitting in the jury box thinking, I've convicted him of first-degree murder, intentionally killing another person with no legal justification. It's not self-defense, it's not insanity, it's not anything. That is what conviction on first-degree murder is. And so I'm just going to sit here and listen, pretend I'm listening, and then I'm going to vote the way I was going to vote anyway for life or death. That's not what you have to do. The penalty phase requires an open mind. It requires you being willing to listen to both sides, absorb and process that information. Doesn't mean you have to accept it all when you're weighing it. It doesn't mean you have to believe it or not. It just means you have to be open to it and not have made a decision until you've heard all of the evidence in the case, all right? We're going to be asking you some questions about the death penalty. I'm going to tell you what some of them are just so you have some time to think about it. We are going to be asking you about your position on the death penalty. Whether you're pro or against the death penalty, we're going to be asking you if you are someone who, regardless of what the law is, what the evidence or the facts are, could never impose death in a case. And on the flip side of that, we're going to be asking you if you are someone who, upon convicting a person of first-degree murder, intentionally killing another person, the only sentence you would consider would be death. And we're going to ask you whether you can go through the process I just described, the weighing and all of that, with an open mind. Again, those are a few of the questions that you're going to be asked today. Let me switch gears to insanity. The defense has raised, Mr. Lloyd has raised a defense of insanity in this case. This would be in the guilt phase of the case, where you're voting whether or not he's guilty. There is a jury instruction on this that's very detailed, but today, for today's purposes, I'm just going to read you the definition of insanity. A person is considered to be insane when he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. The defense has the burden of bringing forth and proving defenses. So this defense would have to be proven by the defense, not the state, and the burden is clear and convincing evidence. We are going to be asking you about your ability to accept this type of defense and listen to it with an open mind. So you might want to think about that a little bit. And then lastly, I'm going to read you a statement of the case. On the morning of January 9, 2017, defendant Markeith Lloyd is alleged to have entered the Walmart store at 3101 West Princeton Street. Mr. Lloyd had an active warrant for his arrest. Orlando Police Lieutenant Deborah Clayton attempted to take Mr. Lloyd into custody on the information she received regarding Mr. Lloyd's involvement in the Dixon homicide, when it is alleged Mr. Lloyd shot and killed Lieutenant Clayton following an exchange of gunfire before fleeing the Walmart and eventually being apprehended about a week later. Mr. Lloyd's trial for the killing of Sade Dixon and her unborn child began on September 27, 2019, and concluded on October 23, 2019. Mr. Lloyd was convicted and sentenced to life without the possibility of parole. That last paragraph I read to you all about Ms. Dixon and the unborn child, she was pregnant at the time. That cannot be used by you to determine whether or not he's guilty in this case. These are two separate cases. The state has to prove guilt independent of that. That can only be used in the penalty phase. We will be asking you some questions about your ability to follow those instructions. All right, folks, I'm going to ask you some questions. For these, all I need you to do is raise your paddles. Once I call out your number, you can put the paddle down. How many of you have heard about this case? All right, so I have 50, 54, 1, 2, 10, 23, 27, and 2. Of those of you who've heard about the case, how many of you have formed an opinion as to Mr. Lloyd's guilt? 23. Anyone else? 2. Is that a yes, no, or maybe? You're kind of doing this, so, okay. A 2, all right. Anybody else I missed? There's 2 so it's the 2 from panel 10, not the 2 from panel 8, or 9, sorry. There's a lot of panels in here today. Next question. Is there anyone in this group who has a religious, moral, or personal objection to the death penalty such that you would never be able to consider the death penalty as an option? Juror in seat number 1. Okay, hold on. All right, from panel, what panel am I on? 8? From panel, I'm on 8. From panel 8, I have 49 and 50. Thank you. From panel 9, I have 1, 13, 17. And from panel 10, I have 2. All right. Flip side of that question, is there anyone on the panel for whom, if you convict someone of intentional first-degree murder, you deliberately murdered someone without any legal reason to do so or justification for it, you believe that the death penalty is the only appropriate sentence? All right, from panel 9, I have 27 and 35. Anyone else? 23, are you in or out on this one? You don't know. Okay, so I'm going to put you as in for right now, but we'll be asking you more questions. So, and she's from panel 9 also, so 23. Anybody I missed? All right, folks, I'm going to send you back into the jury room. I'm going to start calling folks out. What juror number are you, 50? 49. All right, if you'll stay in the room with us. Everyone else, head for the jury room. I'll get you through here as quickly as I can, folks. Thank you very much. Right. Good afternoon. How are you?
Good.
Okay. So, you're juror 209, correct?
Yes.
Okay. All right, let me ask you a few questions. Let me start with this. Well, first, let me tell you this. We're going to be asking you questions, myself and the lawyers. There aren't any right or wrong answers to these questions. The point of the questions is to figure out whether or not you can do your job in this type of a case, okay? So the only correct answer is the truth. Don't worry about what your answer is, just tell us the truth. You indicated that you have a religious, moral, or personal objection to the death penalty. Is that correct?
Yes.
Which one is it? Is it all of them, one of them?
I'm not okay with the death penalty.
Is it a personal belief of yours?
Yeah, I'm Catholic, so I wouldn't feel comfortable making that type of decision.
Okay. How long have you had that belief?
Since I was, I guess, of age, from what I can remember.
All right. Is your belief, okay, is your belief so strongly held that regardless of what the law is, you could never vote for a death penalty? I can't hear you. I'm sorry, you've got the mic way over here. Okay, go ahead.
I also don't believe in the law. Like, I don't
You don't believe?
I don't trust it. Like, whatever evidence is presented to me, either by the defense team or by the prosecution team, I'm gonna have doubts about it. I
Okay.
just-
State,
We move, Your Honor.
defense. All right, thank you, ma'am, you're free to go. Juror in seat number 50 from panel 8, please.
In the restroom, Judge.
Okay, while I'm waiting for that one, I've received a notification of juror in seat number 38 from this panel, the gentleman who was having the PET scan. He is unable to serve. I have a note from a doctor that, once again, I cannot print. Things are going really well in this courtroom. So it's up here on my screen if anybody wants to read it.
No, thank you, Your Honor.
All right, so juror in seat number 38, who is juror number 246 from panel 8, is being excused for medical reasons. Is there any sign of 50? Because I can move on to the next one.
What's your next pick if 50's not ready?
If 50's not ready, give me juror in seat 54, please.
50? Yeah. Okay.
All right.
50.
Good afternoon, how are you?
Good, how are you?
All right, have a few questions for you. There aren't any wrong, right answers to this. The point of the questions is to find out if you can do your job as a juror. We need to know that, you need to know that. So the only correct answer is the truth. Let me start with, you indicated a couple of things. Number one, that you know something about this case, is that correct?
Yes.
I'll get back to that in a minute. But secondly, you indicated that you have a religious, moral, or personal belief which meant that you could never vote for death. Is that correct?
Yes.
Which one is it? Is it religious, personal, or moral, or all three?
Kind of all three, to be honest with you. It's something that I just don't know for sure that I could make the choice. I think I don't know. It's just
Right.
a heavy weight to bear, so I'm just not sure that I can make the choice.
All right, let me start with, how long have you held this belief? Well, you know what? Tell me what the belief is. What is your position on the death penalty?
I don't know. I'm really kind of in the middle on the death penalty. I think in certain situations, I understand why it's used.
Okay?
And I understand, I think living life in prison is a death penalty in itself too. So I don't know, I'm kind of on the fence about it all.
Okay. So, you heard me describe what a juror has to do in this case, all right? You have
Yes.
to have an open mind about, you're never required to vote for death, but you have to be able to consider it, and if that's where the vote leads you, you have to be able to vote for that. Again, you're never required to vote for it, and I don't want you to think that, but you have to at least be able to fairly and openly consider it. So the question, and you're the only person who can answer this question, is, do you believe that you could fairly and openly consider a death sentence, and if you believe that the evidence and the law led you that way, you could vote for it?
Yes, I do.
Okay,
I think I could.
so tell me what you know about Mr. Lloyd's case.
Pretty much just only what you've read so far. That's the same things I've heard. I heard it was a shooting of a police officer, and then a mother and unborn child.
Okay.
That's all I've heard about it.
Where'd you hear it?
Coworkers.
And what else did they say about it?
My boss is convinced that he's guilty. So
Okay.
I did hear that. I've heard that people have said that.
Do you like your boss?
I do. I do.
You have to be careful because it's being recorded.
Yes, I do like my boss.
I don't want you to say anything that could get you in trouble. And the question I'm actually asking you is your boss someone that you respect who would have some influence on your opinions?
Probably. I was trying to not hear anything about any of the case because when I first walked in, like I didn't know anything about it. But when I told work I'd have to serve jury duty again, everyone just started talking, and I tried to not listen to as much as possible. But that is what I heard, and I unfortunately do think it puts like a thought in my mind of potentially respecting that opinion.
Okay. So jurors have to begin trials presuming someone to be innocent until and if the state can prove them guilty. You know what? Some folks can do it and some folks can't. So which one are you?
I think I could. I feel like I'm pretty open-minded, and I do try to look at facts and both sides. The only downside of that is I would say I'm like a very emotional person. So trying to remove the emotional aspect of it, I think is something that would be difficult for me, and to not try to include any of the other information that we know about the case without letting that emotion conflict with my opinions.
Right, so by that you're talking about the previous conviction for the murder of Miss Dixon and her unborn child?
Yes.
All right. You can't consider that in the guilt phase. You can in the penalty phase, but you can't in the guilt phase.
Okay.
Are you telling me that you have some doubts about whether you can put that aside in the
Yes.
guilt phase?
I do.
That it'd be floating in your head thinking, he did that one, he probably did this one.
I do, yes.
Okay, thank you. State.
We move, Judge.
Fence? Yes. Mhm.
Hello.
Hi.
You heard the judge mention that Mr. Lloyd has pled not guilty by reason of insanity in this case,
Yes, I did.
which means he's saying he did it, he's just not guilty because he was insane at the time.
Right.
Does that make sense?
Yes, it does.
And so the question is more so, understanding he's already been convicted of this other crime, do you think you could still consider whether or not he's not guilty by reason of insanity in this case? Does the distinction make sense what I'm trying to get at?
Kind of, if you could explain it a little bit more.
Sure. He's not disputing that he's the person that pulled the trigger.
Okay.
Okay, not guilty by reason of insanity. The judge gave you a little bit of an overview saying, it's somebody who doesn't know what he's doing or can't make his behavior conform with the law, basically, right? You're gonna get way more instructions if you're selected, okay?
Right.
But understanding that he's pled not guilty by reason of insanity versus saying, I didn't do it, I don't know anything about it, do you think that you could hold the defense to our burden of proving him not guilty by reason of insanity, even though you know he's already been convicted of another murder?
Yes.
Okay, I have nothing further.
Let me see the attorneys at the bench. I'll be right with you, ma'am. Give me 1 second, ma'am. All right, let me ask you a few more questions. So you said you can't put, don't let me put words in your mouth, okay? I'm just trying to figure out what you're telling me. I
Yes.
need to be very clear on what you're saying.
Yes.
You cannot put the murder of Miss Dixon and the unborn child aside in deciding guilt, but it would not affect your ability to decide whether Mr. Lloyd, whether the defense had proven Mr. Lloyd was insane or not?
Yes, I guess that's what I'm saying. I think I'm partially like the emotional side of it is, I don't know, I feel like I would definitely let the other trial influence that, because if it happens twice, you know, like I feel like that's like where my thought process would go. If it can happen once and it happens again, like, is it insanity the whole time? Is it, you know, insanity in this case only? You know what I mean? I think that's where my mind would, that's where I would question at least.
Okay. So let me ask you a different question, which is
Okay.
this. Let's say you didn't, at the end of the case, you find him guilty of first-degree murder beyond a reasonable doubt, all right? So now we're in a penalty phase. You have to be able in a penalty phase, like I told you, to consider the aggravators, consider the mitigators fairly and openly, and then weigh all of that before you reach a decision. If you reached a penalty phase in this case, would you be able to fairly and consider and openly consider aggravators and mitigators, or would you be thinking first-degree murder of a law enforcement officer, I'm voting death? I have two different questions for you, so that's the first one.
Okay. I don't know. I think I would struggle giving the death penalty. I do. I'm not necessarily for or against it, but I don't know that I personally could say, like, I want to vote death on someone and
Okay.
make that choice.
And so would that change if it's first-degree murder and he's previously committed this murder of Miss Dixon and her unborn child? Does that change your answers in any way?
No, I don't think so.
Right, so in order, again, like I told you, you never are required to vote for death, but it's the end of the case, you've heard all the evidence, you've heard the aggravators, you've heard the mitigators, you're back in the jury room, you're weighing all of this. If the evidence, the law, and your thought process, if you believed that the appropriate sentence was death, could you vote for death?
I don't think so.
Okay. State.
Can we renew our motion?
Fence. All right. Ma'am, I think on the issue of the death penalty, I'm going to, on the ability to fairly weigh a death sentence, I'm going to excuse you as a juror in this case, but we really appreciate your openness and honesty.
Thank you.
Have a good day. Thanks.
Thank you very much. I appreciate it.
I'm not on that right now. Mine's working, I think. Can you type something, please?
I'm sorry?
All right, it's back on again, thanks. All right. We're good. The transcript wasn't running, and now it suddenly started running again. Juror in seat number 54, please. Good afternoon, how are you?
Good, how are you?
I'm hanging in there.
Excellent.
All right, we have some questions for you, sir. There aren't any right or wrong answers to these questions. As I told you, the point of the questions is we're trying to determine whether or not you could do your job as a juror in this type of case. We need to know that, you need to know that. So the only correct answer is the truth. You said you'd heard about this case, is that correct?
Yes.
How much have you heard about it?
To the, I guess when it happened, and then the manhunt, and to the end,
What do you mean till the end?
when he was found.
Okay. What do you remember about when he was found? I'll start backwards. What do you remember about when he was found?
I just remember him being brought in, and on TV, just being handcuffed and brought to jail.
Anything else you remember about that?
No.
No?
No.
All right, how about before that? Like I said, I was going to go backwards.
Yeah.
What do you remember about before that?
Just the female officer was shot. Another officer was killed in transit, I believe, and going to the scene. Yeah, and that's about it.
Since that time, have you watched any coverage of the case?
No, I mean, if it's come on between, on Spectrum News or something like that, but not that I've tuned in to see it.
Anything that you read? Anything on Facebook? Anything like that?
No,
No?
no.
At the time this was all going on, were you talking to friends and family, coworkers about it?
At the time it was going on, yes.
Okay. Do you remember what the conversations were about?
No, just I think normal, just, kind of unbelievable type stuff, unfortunate stuff, things like that.
Okay. Did you form an opinion at that time as to whether or not Mr. Lloyd was guilty?
Yeah, I have to say, yeah, from news coverage and everything, yes,
What was that opinion?
that he was guilty and they were looking for him.
Right. Jurors in all criminal cases have to be able to presume a defendant to be innocent until and if the state can prove he's guilty beyond a reasonable doubt.
Yes.
Sometimes folks can do it, sometimes they can't. Do you think you can do it in this case, or would you start out thinking he's probably guilty?
No, I'd look at the evidence.
Okay. So I'm going to give you 3 scenarios. You tell me which one applies.
Okay.
All right? And if none of them apply, tell me that.
Okay.
All right. The first scenario, it's the first day of the trial. You're sitting in that jury box, haven't heard anything, you're just waiting for us to start. And you're sitting there and you're thinking, this man's innocent, the state needs to prove to me that he's guilty beyond a reasonable doubt. Scenario number 2, you're sitting there thinking, he's probably guilty, but I'm willing to listen and see if he's not. Scenario number 3, I think he's guilty, but maybe he can convince me otherwise. Do any of those 3 apply to you?
2 and 3 are a little similar, so I think 2.
Okay, thank you. State.
We move, Your Honor.
Defense. Thank you. All right, sir, thank you very much. You are free to go. I'm excusing you from this jury.
Thank you.
Thanks. All right, from panel number 9, juror number 1. Good afternoon, how are you doing?
Good afternoon, God bless.
All right, I know this is not the most comfortable situation in the world for you to be in. Try to relax as much as you can. I'm going to be asking you some questions, and so are the lawyers. There aren't any right or wrong answers to these questions. The point of the questions is to find out if you could do your job as a juror in this type of case. So the only correct answer is the truth, okay?
Okay.
So let me start with, you said you have a personal, religious, or moral objection to the death penalty. Is that correct?
Yes, correct.
And which one is it?
The coastal, we don't judge nobody for their actions.
So you don't, your religion prohibits you judging other people?
Yes.
Is there any case, regardless of what the evidence, the law, the facts were, in which you could vote for the death penalty if you thought it was appropriate?
No, I don't vote for the death
Okay.
penalty.
State,
We move, Your Honor.
defense? All right, thank you, ma'am. We appreciate you coming in. You're excused as a juror.
Thank you so much.
That's, you're juror 786, right? Yeah. Okay, she's gone.
Yes, she is, Judge.
Thank you. Juror in seat number 2, please. This is still panel 9.
I'm sorry, 2?
2, panel 9. So I have 2 2s.
Just in case Your Honor may have written it down wrong, I don't think juror in C2, panel 9 had any objections. It was C2, panel 10.
Seat 2, panel 9 had knowledge. She's
Oh, I'm
being called
sorry.
in here for knowledge.
Yes,
yeah.
Your Honor.
But no, I appreciate it because it is getting a little
Yes, Your Honor.
confusing.
Thank you.
Yeah, thanks. I'm sorry?
You can just refer to the juror on the record.
I'll try, but may or may not happen.
We doubt it.
Good afternoon, how are you?
Good afternoon, Your Honor. I'm good. How are you?
I'm well, thank you. You're juror, you're in seat number 2, but you're panel 9, so you're juror 723?
Yes, ma'am.
Okay, I just have to keep straight who I'm talking.
Understood.
I'm going to have some questions for you. The attorneys may have some questions for you. There aren't any right or wrong answers to these questions, ma'am. The questions are being asked just to determine whether or not you can do your job as a juror in this type of case, all right? So the only correct answer is the truth, okay? You said you had some knowledge about this case. Can you tell me what that is?
Just that it occurred, it was in the news, just mainly headline stuff.
All right. And the stuff that you're talking about, was this when it first happened or throughout the years, or what are we talking about?
No, just pretty much when it first happened. I used to travel a lot for work, and I don't think I was in Orlando when this first occurred. So it would have just been that it did occur, and then probably, I think it was just when it first occurred. I didn't really follow anything afterwards. I did not follow anything afterwards.
Did you have any conversations with anyone about it? Co-workers, family, friends, anything?
Not that I recall.
And did you form an opinion about whether or not Mr. Lloyd was guilty based on what you were hearing?
No, because I didn't follow the cases or anything.
And subsequent to that time, you haven't heard or read anything?
No.
Do you have a position on the death penalty, ma'am?
How so?
Well, are you someone who is against the death penalty, for the death penalty? Have you ever thought about it?
Yes. So with regards to the death penalty, I am more so with regards to following the law. I'm not against it. I'm not, super pro, super anti-death penalty. I just would be whatever the circumstances are of the case, of the situation, and how it applies to the law.
Okay. Let me ask you some specific questions about the death penalty then. The law in the state of Florida requires, number one, a conviction for first-degree murder.
Yes, Your Honor.
Premeditation, intentional killing, no legal justification. That's first-degree murder, all right? So you set out to kill this person and you had no legal reason to do so. It's not self-defense, it's not insanity, there's nothing there, all right? The jury has convicted that person and found them guilty beyond a reasonable doubt. You with me so far?
Yes, ma'am. Yes, Your Honor.
All right. So at that time, just hearing that, conviction, no reasonable doubt, first-degree murder, Are you someone who thinks that the sentence for that should be death?
I guess I would want to know the circumstances of everything.
All right.
If everything met, the determination of that, I would have to.
You can't say right now is what you're.
Correct, yes.
All right. If I add to that the fact that it's a law enforcement officer, would that change your answer in any way?
I would still want to know the details of the case.
All right. And then if I add to that a conviction for a previous murder, would that change your answer in any way?
Still, again, the details of the case.
Okay. That is Florida law. All right. As I explained to you, if you end up in a penalty phase, there's another trial. State's going to put on the aggravators, the reasons they believe you should vote for death. Defense is going to put on mitigators, the reason they believe you should vote for life without parole. You've got to listen with an open mind. You have to be willing to absorb that information and process it. Can you do that?
Yes, Your Honor.
All right, and then you're going back in that jury room to personally weigh the aggravators and mitigators. If that process led you to believe that the sentence should be life without the possibility of parole, can you vote for that?
Yes, Your Honor.
And if that process led you to believe that the sentence should be death, could you vote for that?
Yes, Your Honor.
All right. The insanity defense, as I told you, Mr. Lloyd has raised the defense of insanity. This would be in the guilt phase. You're trying to decide whether he's guilty or not. If at the end, the burden's on the defense to prove that. But if at the end of the guilt phase, states put on their evidence, defense has put theirs on, you believed, you were convinced by the defense's evidence that Mr. Lloyd was insane, could you return a verdict of not guilty by reason of insanity?
Yes, Your Honor.
And then my last question is, can you put aside the murder of Ms. Dixon and her unborn child during the guilt phase and not consider that in determining whether or not he's guilty of these charges?
Yes, Your Honor.
All right, thank you, ma'am. I don't have any other questions for you, but I'm sure the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon.
Good afternoon.
So we have the answers or responses that you gave to the questionnaire that you filled out.
Yes, sir.
I'm going to ask you a couple of questions about those responses. You have close friends or family, close friend or related to a law enforcement officer?
Yes, sir.
Is that tied to your employment?
Both.
Both.
Yes.
So you have friends.
I was previously a police officer in Gainesville.
Okay, and how long did you do that?
Just under a year.
And did you go from that to your current role?
No. I mean, essentially, yes, but not directly.
Understood. I have to take notes every now and then so I can remember, so please forgive me. People who you do not know, well, can you give us a quick summary of what you do currently, if you're allowed, because I saw what it is and I don't want to get you in trouble.
I appreciate that. I do background investigations for the government, for anybody that needs a security clearance, like military, defense contractors, that type of
I
thing.
completely understand now. Okay. And how long have you been doing that?
Close to 15 years.
Who is close to you in law enforcement that is not related to your employment?
Like family or friends? Or?
Yes, ma'am.
Okay. Friends, it's Dr. Ross Wolf with the Orange County Sheriff's Office.
You don't need to give me the exact
Oh, okay.
names. I'm just
Sorry.
mean, what's their role in law? I didn't clarify that. It's my fault. What's their role in law enforcement and the nature of your relationship?
Okay. The person is a reserve, and he was my mentor advisor through college. And another person I stayed friends with after college. Different person stayed friends with after college. Do you need their employment or what? Sorry, what information do you need, sir?
What agency do they work for?
Orange County Sheriff's Office.
Okay. Go ahead. Anybody else?
There is another friend that I went to the academy with. Kind of brief contact there with the Alachua County Sheriff's Office. And you're looking for law enforcement?
Yes, ma'am.
Okay. There's nobody that really sticks out to me at this point that I'm friends, that I consider a closer friend I maintain contact with, that is local law enforcement, that I can think of right now.
Yes, ma'am. Anything about your relationship with those individuals or your current role or your prior role in Gainesville that you think would prevent you from being fair and impartial in this case?
Not at all. I actually think my current position enables me to be completely impartial, because with investigations, I see all the time that on paperwork and what you do after the investigation and the evidence that you get can be 180 degrees from what was on paper.
Yes, ma'am. So you told us that your position on the death penalty, and I'm summarizing essentially, was more in regards to following the law.
Yes, sir.
So you're not for or against capital punishment as a principle?
Correct.
Now, I think I heard you say that after having a description from the court about the process, that you could vote to impose either sentence or have either sentence imposed based upon where the facts in the law lie.
Yes, sir.
Do you remember the court discussing with you the weighing of aggravators and mitigators?
Yes, sir.
So the key part to that is your willingness to give meaningful consideration to both. Ultimately, you decide how important one thing is. That's what that weight part of it was. And I'm not trying to talk down to you. I just know that this process can be confusing.
I appreciate that.
But before making any decision, you have to be willing to consider whatever you hear, regardless of where you are in the matter. Right?
Yes, sir.
Is that your understanding?
Yes, sir.
Regardless of what aggravators you hear and how emotional or strong you may feel about them, could you withhold judgment and give meaningful consideration to any mitigating circumstances that you heard about Mr. Lloyd's life, background, or defense in regards to any potential penalty that may be imposed if he's convicted of first-degree murder?
Yes, sir.
That was a long question, I know. I apologize. Is there anything about your, well, let me back. I should have talked about insanity first, I apologize. Because of that defense and its nature, I need to ask you if you or anyone personal close to you have dealt with mental illness in your life.
In what fashion? What do you mean?
Suffer from it, gotten treatment for it, study it, anything that would give you insight into the concept of mental illness.
Well, I mean, I deal with that with my job. You know, we do have subjects that are declared mentally incompetent, and
Okay.
I wind up reviewing a lot of medical records with my job.
That's the kind of information I'm looking for. Given your contact with that topic in your job, do you believe that mental illness is a real thing?
Yes, sir, definitely.
I ask that because there are portions of our society and community or people in them who don't believe that.
Right. Correct, sir.
Given that belief, do you think that you could fairly weigh and consider any information or evidence presented to you on the issue of whether Mr. Lloyd is not guilty by reason of insanity?
Yes, sir.
And if it were proven to you, could you find him not guilty by reason of insanity?
Yes, sir.
My last question, ma'am, is there anything in your background or life experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury that we can for this case? You've already given us a couple of examples, the insight into what you do. Anything like that, other than what we've discussed, that you think we should know?
No, it really was just what I had mentioned earlier. Is I understand I have a obvious background in criminal justice, law enforcement, but with my current job, it is weighing
the facts, it's weighing the evidence, it's, going over that in minutia, in detail, to come out with the best information to be able to make a determination.
And I should have asked you this. Your juror information says you have never been a juror before.
Correct.
Have you ever been called up like this?
I have.
On multiple occasions?
Yes.
That's why I wanted to ask this question. On a scale of 1 to 10, 1 being you can't wait to get out of here and go back to your job and your life, and 10 being you're uber excited about the prospect of being a juror, where would you put yourself?
I would say in the middle. I think professionally, this is what I've learned about and gotten schooling on and whatnot. However, I am quite active, and I, do have my own personal life. But I also think being a federal employee, I am able to take off of work and be here for the required amount of time, where I understand that is hard or nearly impossible for most people. I think I am interested, and I think I would be impartial and interested. I think that's I would be interested, whereas I wouldn't just be here out of complete obligation and required to be here and hate, like you said, hating every minute of it. I think, I guess just kind of in the middle.
Yes, ma'am. Thank you. Thank you, Honor.
Thank you, Mr. Williams. Ms. Miller, remain quiet.
Hello.
Hello, ma'am.
Where you're currently employed is not a secret, is it?
No.
Okay, we've all been beating the Department of Defense, correct?
Yes.
Okay. You were previously a law enforcement officer with the Alachua County Sheriff's Office.
No, Gainesville Police Department.
Got it. Any other law enforcement agencies?
No. Not as a law enforcement officer. I worked for University of Central Florida Police Department. It was like I drove golf carts around.
Was that your job title?
It was awesome. Best job ever.
Driving golf carts around?
Yes.
Any other law enforcement agencies, either law enforcement or civilian?
No.
Okay. And you said that, my curiosity was piqued when you said that you went not directly, but essentially from the Gainesville Police Department to your current employment. What does that mean, please?
I moved from Gainesville back to Orlando because I have family and friends here, and didn't come back here immediately into a job. So I worked at a home builder for a couple of years before getting into this job.
Gotcha. And I think you can probably appreciate why we ask some of the questions that we do, right?
Sure.
The goal is to find jurors who can be most fair for this case. And it's not a reflection on any particular juror. Everybody comes into this with their own background, walk of life, right?
Understood. Yes, ma'am.
And so I want to talk a little bit more about the victim in this case being a law enforcement officer, right?
Yes, ma'am.
And certainly it wouldn't be fair, I think you would agree, to the state if the jury was composed of Mr. Lloyd's family, right?
Right, correct, ma'am.
And my understanding is law enforcement sees itself as a type of family. Would that be fair?
Yes, to a certain extent.
And so, I don't think anyone doubts your ability to follow the law, right? And all of those laws will apply to you if you are selected as a juror in this case. Right now, the oath that you took was to tell the truth. And so I am genuinely asking about your feelings, right? I want you to envision yourself being in the deliberation room, trying to decide if we've met our burden of proving Mr. Lloyd not guilty by reason of insanity. And would you struggle to acquit him? Not guilty by reason of insanity is still not guilty of the crime of murder of a law enforcement officer given your background?
Not if the evidence is there.
Okay. Same type of question about the penalty. So now you've convicted him. You've rejected that defense. He's been proven guilty beyond a reasonable doubt of the intentional, premeditated killing of a law enforcement officer. Thought about it, he meant to do it, and he did it. No legal excuse, justification, or defense. You're being asked to decide what the appropriate penalty is, life or death. Do you think you would be feeling pressure to sentence him to die because of your background?
Not at all.
Okay. Tell me what you're thinking.
Just that. I don't see why there would be any pressure to, or expectation of me or anybody to sentence him to death.
Okay. And maybe I'll just tell you what my fear is, right?
Sure.
So some folks that have background in law enforcement, related to law enforcement officers, feel pressure, like I have to go back to my loved one, my family and friends, who at some point are probably going to realize where you are, and they may question why you did something. And some people say, yeah, that wouldn't bother me. And some people say, yeah, I think that might creep into my mind, envisioning going to talk to my friends that you talked about in law enforcement and having to explain myself. Does that make sense?
Yes, ma'am.
Does any of that apply to you at all?
No.
Knowing someone has been previously convicted for another murder and is serving life in prison, does that make you feel that the appropriate punishment for this second murder, the only appropriate penalty, should be the death penalty?
No, ma'am.
Why not?
Because it's two different trials, two different situations. It's separate.
Okay. And you're exactly right. And the judge has instructed you, and she'll explain more, that because he's guilty of one other case doesn't mean he's necessarily guilty in this case, right?
Correct.
But you are allowed to consider that he's been previously convicted, Mr. Lloyd, of another murder and is serving life in prison. We're deciding what the appropriate, considered an aggravating factor in Florida. With me?
Yes.
And again, some people say to me, listen, if I know he's already doing life for another murder, really that death becomes the only appropriate penalty here. Does that make sense?
I understand what you're saying.
Does any of that relate to you at all?
No, ma'am.
Okay. Mitigation, right? Some of these aggravating factors are huge. The murder of a law enforcement officer, prior conviction for murder, and mitigation can be seemingly somewhat small. And so when we talk about being able to give meaningful consideration to something, I think you can appreciate this. It means hearing it, internalizing it, and it potentially, doesn't have to, but potentially having impact on what you think the verdict should be, life or death. Does that make sense?
Yes, ma'am.
So if I asked you if you could consider somebody experiencing the effects of racism and give that meaningful consideration as to life or death, do you think you could do that?
Yes, ma'am.
Okay. You will not be surprised to learn, or I suspect you won't be surprised, that sometimes folks have differing opinions on these sort of things. Fair?
Yes, ma'am.
And that's why death is never required, not in any case. And so, I hear you saying, I could follow the law, put these facts as the judge instructs, right? So if we're in the second part of this trial, and you're trying to decide if you're trying to decide the appropriate penalty, the first question is, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And then the last question is death the appropriate penalty? And so even if all of these are yes, 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 you can always answer no to that last question. Does that make sense?
Yes, ma'am.
And so that's why we talk about feelings, because there really is no right or wrong answer. You apply the facts to the law and you vote your conscience. Make sense?
Yes, ma'am.
If one juror decides that life should be the verdict, then life will be the verdict. Are you okay with that?
Yes, ma'am.
And we talk about mitigation a lot. It is simply why one juror would choose life or not choose death, okay? And that's what another example, it could be simply a smile observed between the defendant and a family member. And for that juror says, I assign the weight of life to that, and I'm not giving a death sentence in this case, and that's okay. Mitigation doesn't have to be unanimous, and it can be unique to each individual juror. Make sense?
Yes, ma'am.
You are certainly not going to allow anybody else to bully or badger you into changing your individual moral assessment once you've reached one, right?
Correct, ma'am.
And you wouldn't bully or badger anybody else to agree with you if they had a differing opinion.
Correct.
Can I have just a moment, Your Honor?
Yes, ma'am. All right, thank you. Either side need to approach.
No, Your Honor.
All right, ma'am. We're going to send you through to the final round of questioning in this case. And that means that if you'll hand your badge to the deputy, you're going to become a purple dot. Like I said, I use the colors to call people in because too many numbers. So
Yes, Your Honor.
we're going to give you a packet. In the packet is a slip of paper with a phone number on it to call to find out when you're supposed to report back. I don't actually know the date. I strongly suspect it's next week, but I'm not 100% sure. So if you'll call starting tomorrow after 5, eventually you're going to hear purple dots come in. If you don't hear anything, you're not being called in yet, all right? The day you come back, we're going to pick the jury and sequester the jury. So you'll need to have packed a suitcase, leave it in your car. If you need it, we'll have you go get it. If not, you can just drive home with it. There's also a sequestration packet in there that explains to you what it's like being sequestered, what the rules are, and gives you some suggestions about what to bring with you. And lastly, there's a letter for your employer telling them that you're coming back for one more day. Do you have any questions?
No, Your Honor.
All right, thank you so much. We'll see you next time. We appreciate your time this afternoon.
Thank you.
All right. Need this jury in seat number 10, panel 9. I'm sorry, panel 9. It's juror 3374.
How's this?
Good afternoon, how are you?
Good afternoon. Is this okay? I echo.
Yes, we can hear you.
She said
It may be
present.
echoing a little to you, but we can hear you. All right. Have some questions for you, and then the lawyers probably are going to have some questions. There aren't any right or wrong answers to these questions. The point of the questions is to find out if you can do your job as a juror in this type of case. It's something we all need to know, including you. So the only correct answer is the truth. Let me start with, you said you had heard some things, you had heard about Mr. Lloyd's case. Can you tell me what you've heard?
Up until you read that, I had read that. I do remember on the park and mentioned, I think must have been early evening because they broke Jeopardy to report it. That's all I remember.
Okay. Do you remember talking to anybody about this case? No? Okay. Did you watch anything after the arrest?
I don't intentionally watch the news, and I don't get newspapers, but that's the clearest thing into Jeopardy to prevention.
Okay. Did you form any opinions as to Mr. Lloyd's guilt based on what you saw or heard?
No.
Jurors have to be able to presume, in any criminal case, you have to be able to presume the defendant innocent until and if the state proves they're guilty beyond a reasonable doubt. Do you believe you're able to do that in this case?
I do.
All right. You're juror 3374, correct?
Yes, ma'am.
Okay, sorry.
The reason I think it's not clear, I'm sorry to interject, but had I been paying attention and watched a lot about it, I think I would have remembered a pregnant victim. I really think I would have remembered that. That's something that like would have stuck out. And,
Okay, it's okay that you don't remember. So, are you someone who has any strong opinions about the death penalty one way or another?
well, that's why I spend most of my time back there thinking, and I settled on reluctantly in faith. That reluctantly means I can't go in there and say, okay, first-degree murder automatically deserves death. But if I imagine myself in that phase, assuming I got to that phase, that in my mind I imagine there's some gap between life without possibility of parole, and death. And aggravating factors are trying to build a bridge over it, and mitigating factors are trying to knock out the steps, and eventually I'll be able to walk across. And I know that's the best way I thought about it is. But if anything matters, if anything's relevant to you, I think it's that in my mind, bridge towards death, not that I'm standing on death and mitigating factors have to move me away. It's the bridge, the mitigating factors go towards death and the mitigating factors come back. And that's why I settled on reluctantly in favor, I guess, if that matters.
Okay, you have managed to answer all of the questions I would have asked you, and I appreciate that very much. About the death penalty, I'm moving on to insanity. Your position is completely accurate as to what the law in the state of Florida is. The only question I would ask you is, if after all the process you believed the appropriate sentence was life without parole, could you vote for that?
Yes.
And if you believed it was death, could you vote for that?
Yes. I imagine that if I'm in that phase, that, like I said, there'll be something that I'll remember, and as you said, I'll weight them, and I'll either be able to, justify that decision, or I won't.
Okay.
And I don't know what that's going to be or how it's going to happen, or if it does.
Today, all we're trying to find out is if you can do it. Later on, you'll find out more details, but.
I do, but I believe I.
Okay. The insanity defense. Mr. Lloyd has raised that. It is the defense's burden to prove it. But let's say you're at the end of the guilt phase when you're trying to decide whether or not he's guilty. If at the end of that phase you were convinced by their evidence that he was insane at the time of the offense, could you vote not guilty by reason of insanity?
If I believed it, I guess I'd have to.
All right. And then my last question to you is, you remember I told you about the previous conviction for the murder of Miss Dixon and her unborn child?
Yes.
Is that something that you can put aside in the guilt phase? Because it has nothing to do with whether he's guilty of this or not.
Yes.
It can be considered in the penalty phase.
Yes.
Is there anything
That's a
about...
completely different crime, and nothing about it matters here.
All right,
So
is there anything about that would... Never mind, you've answered my questions. I don't have any other questions for you. State, you may inquire. Mr. Williams?
Thank you, Your Honor. Good afternoon, sir.
Good afternoon.
That bridge thing, I may steal that.
Okay.
Because that's pretty good.
I had a lot of time to think. I was,
Well, you used it wisely. The only real question I have for you about the death penalty, and the judge asked you, but I'm going to drill down a little bit more, is not in the theoretical sense while you're contemplating it and whether you could do it, but like in a real sense, understanding that if you're selected as a juror next week, you could be put in this actual position.
Yes.
Could you, if the evidence led you and the law authorized you in your mind, could you walk across that bridge and actually say, yes, I'm raising my hand and voting that a sentence of death be imposed upon another human being? Could you do that?
Yes.
And conversely, if it weren't proven to you, or you believed it was not authorized, or you just thought that it wasn't appropriate, could you vote for life in prison even if you really thought the crime was bad?
Yes.
Okay, thank you.
I think a conviction for first-degree murder is bad, and it seems that affects some, like I said, some measure of a gap between those two sentences that has to get bridged or not. But
And the party's job in this case to fill that gap for you with the information that you provided, and I assure you that will happen. But I have no, yes, sir. So when you were asking answering the judge's questions about insanity, unfortunately, we listened very carefully to everything you say, and you said that you could find Mr. Lloyd not guilty by reason of insanity. And you said, I guess I'd have to. And I interpreted that to mean that if the law said it in your mind that you had to, that's what you would do.
no, she asked me that if I believed that, would I be able to say it? And that's why I said, I guess I'd have to, because if I believed that, then yes, I'd have to say that.
Okay.
If I'm convinced that insanity played a factor. Good. Yeah.
Understood. And you clarified that for me.
Okay.
Because of the nature of that defense, I need to ask you a somewhat personal question, and that is whether you or anyone close to you have suffered through or experienced mental illness.
Mental illness? I don't know. My daughter was just diagnosed bipolar, but
Okay.
that's kind of like therapy, so I don't know.
That would qualify. And what I tell people is if you're not sure if you should tell us something that pops in your head, then tell us, and you did. So, is she getting treatment, did I hear you say?
Yes.
Okay. Is that helping, do you think? Or is it too early to know?
I don't know. I haven't spoken to her since Friday because
Okay. So is that a recent thing?
my wife is kind of running interference for me.
Is it a recent thing, the diagnosis?
It was yeah. She used that to switch from a therapist to a psychiatrist in the event that they feel medication is necessary, but that's the only mental illness I have direct experience with.
Have you observed your daughter's behavior as a result of that mental illness?
No, she moved out 10 years ago, and she's on the north side of Lake Mary. So
Okay.
I saw her, like 3 times this year.
Understood. There are people in our community and society who believe that mental illness is not real.
Okay.
I take it from your responses and your personal experience that you are not one of those people?
I'm sure it's real.
Well, you say that, but I'm asking.
Psychiatrists exist, and
Okay. So you believe it's real?
insanity defenses exist, so I'm sure it's real. I don't know what you mean. They think it's not real.
There are people who think that mental illness is made up as an excuse or justification for people's actions.
Ah,
Does that make more sense?
yes.
Are you one of those people?
No.
I didn't think so. But given the nature of the defense, I need to ask, right? So I take everything that you're saying to understand you to mean that you could fairly weigh a defense of insanity and find Mr. Lloyd not guilty by reason of insanity if it were proven to you.
Yes. And it has to be proven by them.
Very good. Yes, sir. That's what you were told.
That's it.
The last thing I'm going to ask you is there anything that we have not discussed in your background or life experiences that you think we should know about you, given that we're trying to select the most fair and impartial jury in this case, where death is a potential penalty?
Well, I don't know what to do.
So by way of example,
I'll just go quick.
Yes, sir.
Went to FSU, majored in computer science, went in the United States Navy in 1995, 8 years in the nuclear power program, went to Naval Nuclear Power Training Command here in Orlando at the base that's now Baldwin Park, went to the Theodore Roosevelt, got out, went back to software, did programming and web development since 2001.
Okay. You were 8 years in the Navy, you said?
Yes, sir.
Okay.
Reactor technician.
Anything else?
Reactor technician. Pressurized water reactors.
Thank you for your service and answering my questions, sir. Thank you. I don't have any other questions.
Thank you, Ms. Williams. Ms. Miller, you may inquire.
Hello.
Good afternoon.
I think you and I might be Madam Court Reporter's worst nightmare, the speed in which we speak.
Is it fast? I've been accused of that before.
I don't mean it judgmentally. You'll see.
You should see how fast I type.
I think you probably get where we're going with this, that some people who hear about the intentional, premeditated killing of a law enforcement officer, that defendant thought about it, he meant to do it, and he did it. And there wasn't any legal justification, excuse, or defense. Some people feel very strongly that somebody who is guilty of that crime deserved the death penalty. Make sense?
Yes.
Is that you?
I know some of them. No.
Okay, why not? Why would, you said you know some of them.
Slipping.
I know, they're terrible. Thank you for wearing them. Why is that not you?
Why is that not me? I thought about that too. And Declaration of Independence says that we are endowed by our Creator with certain unalienable. The Declaration of Independence. This is what I came up with when I was thinking about it.
Okay.
The Declaration of Independence, although not a legal document and technically an illegal document at the time, says that we are endowed by our Creator with certain unalienable rights, and among these are life, liberty, and the pursuit of happiness. So,
Slow down just a teeny bit.
okay, I figured since that was a quote, it was probably familiar.
You know what? Why don't, just to help out the court reporter, take off your mask, just pull it down.
Okay, I could.
Unless you, there's no one around you.
I'll go up.
Okay.
Okay, well, I got the Johnson vaccine if that matters.
If you're uncomfortable doing that, put it back on again. If you're uncomfortable taking it off, put it back on.
I'm fine. If anyone else is uncomfortable, I'll put it back
You're
on.
fine.
Like,
Go
just run all the way down. So I think that the default position is there has to be something extra to justify the death, you know?
Sure. And
That's why.
And we call those aggravating factors.
Yes.
They're things that are intended to make a juror think death might be more appropriate in this case. And one of those is the murder of a law enforcement officer.
I see.
Does that make sense?
Yes.
And so certainly that is something that you can say, this makes me lean towards the death penalty.
Okay.
What I want to make sure of is that knowing that alone, you're still willing to consider the other side. And some people say, and there's truly no right or wrong answer.
Is that literally one of the 16 aggravating
Yes, sir.
factors? Okay.
Yes. And so that's where some people say, if I know that to be true, if I'm being honest with myself, I'm not going to be able to give meaningful consideration to mitigation or the
I see what you mean.
the circumstances in favor of life. Does that make sense? What do you think about that?
I think, just like the bridge I imagined in my mind, that it's my duty to consider all of the aggravating factors and all of the mitigating factors, and I have to justify to, not only to my conscience, but to the court, the people, and the defendant that death is appropriate. And so that's, like I said, that's why I said reluctantly in favor, because that's got to be at least some small measure of leap for me.
Okay. And so sometimes, some of these aggravators are huge, right? It's the murder of a law enforcement officer, the defendant being previously convicted of another murder, right? And then I want to ask you about the effects of racism, which may seem small, but could be equally huge. And so do you think that you could consider meaningfully, and that you hear it, you internalize it, and it could affect your verdict as to life or death?
Racism? You mean hearing about racism in the courtroom, or
Hearing about the defendant being affected by racism.
Oh.
Tell me what your thoughts are.
If I had to improvise an answer without significant deliberation, I would say the effect of suffering racism on the defendant would be on the insanity side, I guess.
Sure. It
And
could.
not on the, yeah.
Well, it could be.
And not on the, was this, whatever higher measure of callousness, viciousness, or that pushes to death. You know what I mean?
Yeah.
Effect of racism on the mental state would be probably, something that would, I don't know if that makes sense.
No, it does. And so we're having this conversation a little bit in a vacuum.
Okay.
And we may never even get to the second part of the trial, right? If the state doesn't prove Mr. Lloyd guilty beyond a reasonable doubt, or if we succeed in proving him not guilty by reason of insanity, you would never even be considering penalty, because he'd be not guilty,
Yes.
right? And so I don't want you to think because we're talking about penalty, I'm assuming we're going to get there. I'm not. This is just the only opportunity.
I'm not either.
I don't think you are. This is the only opportunity I have to talk to you, and the law requires us to have this conversation now. So insanity is, right, it's a narrow legal definition, and the judge gave you some of those instructions, that a defendant could not decide between, or could not understand right or wrong, or could not conform his behavior to the law, right? And so you may hear about things affecting a defendant's mental health or mental illness that you don't think rises to the level of insanity, so you still found the defendant guilty, but we're in the second part of this, and you could still give it consideration as to whether life or death are the appropriate penalty. Does that make sense?
Yes.
And so I'm just asking you if you think for you that is something you could do. The effects of racism, mental illness, even if it doesn't meet the definition of insanity, is that something you can consider when deciding whether life or death is the appropriate penalty?
I hope I'll remember and consider everything.
Yep, well, you're gonna be able to take notes, if that's helpful. And you'll get all of the instructions read to you in much greater detail. Just a couple things, death is never required. Not in any case, not in the worst conceivable case you can imagine, okay? And so the second part of the trial, looks like you want to say something. What are you gonna?
She mentioned that.
Yep, sometimes we repeat it. I repeat the judge. In the second part of this trial, the steps are, has the state proven the existence of one aggravating factor beyond a reasonable doubt? Is it sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And the last question is death the appropriate penalty? So even if you vote yes, 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 the last question is never required to be yes, even if all the other boxes are checked. Does that make sense?
Yes, ma'am.
If one juror says that life should be the verdict, then life will be the verdict. Comfortable with that?
Yes.
Mitigation can be
Even if I'm that one juror.
Yep, and that's what, sometimes this is hard. That's why we have this conversation. Because sometimes you're already ahead of me envisioning yourself in the deliberation room, right? And that people have differences of opinion, and sometimes people are strongly opinionated about this. Make sense? And that in order for a just verdict to be returned in this courtroom, all 12 jurors' individual moral assessments about whether Mr. Lloyd lives or dies have to be heard in this courtroom. Make sense?
Yes.
And so sometimes it's hard, but that's what the law requires, and it's your duty, your right, and your responsibility, and you can do that, yes?
Yes.
I got a little, you.
I didn't mean to say like she repeated that. My wife's a school teacher, so I know that the number of times you hear things is directly proportional to how important it is.
Yes, you get exactly where I'm going. We understand each other. So mitigation, I got a little bit off
That's
topic.
true in the military too. That's true in the military too.
Repetition?
The number of times you hear things is directly proportional to how important it is.
I suspect you repeated things a lot when you had control over a nuclear reactor?
Yes.
Okay.
I'm pretty sure.
Mitigation can be absolutely anything. It does not have to be unanimous, and it can be unique to each individual juror. And as we discussed, it can be, at first blush, seemingly small. It could include, a smile observed between the defendant and a family member. So for that juror says, I saw that, I assign the weight of life to that, and I'm not giving a death sentence in this case. Make sense?
Yes.
If you are in the back and you have reached an individual moral assessment, and that is the verdict should be for life, and it's not being respected, you can say, hey, listen, we're done here. I've reached a verdict. Deputy, please get the judge. We can go home. With me? May I have just a moment, Your Honor?
Yes, ma'am. Either side need to approach?
No, Your Honor.
All right, sir. We're going to send you through to the next round of questioning. And so several things are now going to happen. Number one, if you'll hand your badge to the deputy, you can put your regular mask on and you don't have to wear that other one right now. We're going to make you a purple dot. Like I told you, I use the colors to call groups of jurors back in because there's just too many of you to call numbers. So you're now purple.
Is it because you weren't able to hear me?
The mask? The mask causes some problems with sound in this courtroom, so we just have people pull them down sometimes. You do talk very fast.
Back on. Yes, ma'am. I'm sorry.
So anyway, you're going to be returning for one final round of questioning. That day, we will be picking the jury. So we're giving you a package. It includes several things. Number one, it includes a slip of paper that gives you a phone number to call starting tomorrow at 5. You're coming back sometime next week. It's not going to be this week. It'll be next week. So you're listening for the purple group or the purple dots return on this date at this time. That will be jury selection. You'll need to have packed a suitcase because if you're picked for the jury, you're being sequestered that day. Just leave it in your car. we'll make arrangements for you to get it if you need it. If not, obviously, you just go home with it. There's also a letter in there for your employer telling them you're coming back again. And lastly, there's a jury sequestration packet. It explains more about sequestration, the rules, what you should bring with you to coming to sequestration, tries to answer questions you may have. Do you have any questions? 2 to 3 weeks. But we suggest you pack about a week or so because there is laundry there. Okay? So whatever you think you need to survive for 2 to 3 weeks if you do not want to do laundry. All right?
Yes.
Okay. Thank you, sir. Have a good afternoon.
I'll put this back on.
You can keep that lovely mask. It's our gift. You're welcome.
Can't imagine the pressure of these.
The juror in seat 23, please. This is still panel 9. And this is juror 681. Good afternoon, ma'am. How are you?
Can you hear me?
Yes, ma'am, I can. I have some questions for you, and then the attorneys may have some.
Okay.
But there aren't any right or wrong answers to these questions. The questions are designed to determine whether or not you can do your job as a juror in this type of case. It's something you need to know and we need to know. So the only correct answer to the questions is the truth. Okay? So you indicated that you knew something about this case. Is that correct?
Yes.
And that as a result of that, you had formed an opinion as to whether or not Mr. Lloyd was guilty?
Yes.
Can you tell me what that opinion is?
I believe he's guilty.
All right. Jurors must begin trials, all criminal trials, presuming the defendant is innocent until and if the state proves he's guilty. Is that could you set aside your feelings that he's guilty, or do you believe you'd start the trial thinking he was guilty?
I could not set it aside.
All right. Thank you, ma'am. State.
We move, Your Honor.
All right. Thank you, ma'am. You are free to go.
Thank you.
Do I just leave?
Yep. Juror in seat, this can't be right. Oh, 27. Juror in seat 27. Good afternoon, ma'am. How are you?
Good.
Wearing the world's most uncomfortable mask.
Just a little.
Okay. I have some questions for you. So do the attorneys. There aren't any right or wrong answers to these questions. They're meant to determine whether or not you can do your job as a juror in this type of case. You need to know that. We need to know that. That's why we're asking you the questions. So therefore, the only correct answer is the truth.
Okay.
Just tell us what you honestly think, all right? You said you had some knowledge about this case. Is that correct?
Yes.
What do you know?
I can recall, I know it's a while ago, some news coverage when there was the whole trying to find him kind of stuff going on.
Okay. Anything about that you remember?
I mean, just vague, like, that there was a manhunt for him.
Okay. Do you remember anything else?
I mean, I do kind of remember the whole trial. I guess it was in 2019, as you stated. I didn't really follow it, but I remember hearing a verdict.
Okay. Like hearing the verdict read on TV?
Yeah.
All right. Did you talk to friends, family, coworkers, anyone about this over the years?
I might have when the 2019 verdict came out.
Do you remember any of the conversations?
Not really.
All right. Did you follow any of it on, I guess, Facebook or anything like that?
Oh, no.
Did you form an impression as to whether or not Mr. Lloyd was guilty based on all of that?
Sort of.
And what was it?
He was guilty.
Okay. Jurors have to begin trials being able to assume defendants are innocent. That's the rule for all criminal trials. Do you think you can do that in this case, or would you start the trial thinking he's guilty?
I'd have to say I'd start the trial thinking he's guilty.
All right, thank you, ma'am. State.
We move, Your Honor.
All right, thank you, ma'am. You are excused. Have a good day.
You too.
From panel number 10, juror number 2. Is this the right panel? No, this is 8. There's 10.
Sit.
Yes. Good afternoon, sir. How are you?
Good, good.
I have some questions for you. There aren't any right or wrong answers to these questions. The questions are meant to determine whether or not you could do your job as a juror in this case. So the only correct answer is the truth. So you indicated to me that you had some knowledge about this case. Is that correct?
Yes.
And that as a result of that, you'd formed an opinion as to Mr. Lloyd's guilt?
Somewhat, maybe, yes.
Okay. What is that opinion?
Well, he murdered someone,
Okay.
you know.
So to be on a jury in a criminal case, you have to presume someone is innocent until and if the state proves they're guilty. Do you think you could do that in this case, or would you start the trial thinking that Mr. Lloyd is guilty?
No, I think I could. I think I could.
All right, so I'm going to give you 3 scenarios and tell me if any of them apply to you. If they don't, just say so, okay? Number 1, it's the first day of the trial, you're sitting in that chair, we haven't even started, but you're thinking in your mind, this gentleman is innocent, and I'm going to wait and see if the state can prove he's guilty, all right? Number 2, I think this guy's probably guilty, but, you know, I'm willing to listen and see if the state can prove it. And number 3, I think he's guilty, but yeah, I'll listen to the trial, and if I'm convinced otherwise, I'll vote not guilty. Do any of those 3 apply to you?
I would think the first one, I would want to be the first one, yes.
Okay. So let me move on to my next question for you, which is, you indicated that you have a personal, religious, or moral objection to the death penalty. Is that correct?
Yes.
Which one is it?
More morally, I don't know if I could, to that point, to put someone, you know, on death row, yes.
Okay. How long have you held that belief?
Probably all my life. You know.
Is that belief such that regardless of what the evidence, the facts, or the law was, you could never vote for death?
I don't, no, I couldn't say that, no.
Okay.
Yeah.
What could you say?
Yeah. Yeah, I don't know. If it came down to it, if I had to, I guess, but I just, like I said, in my heart, I wouldn't feel like right to, you know, to do that to someone. I mean, even though the evidence might show it.
All right, and like I told you, there aren't any right or wrong answers to this, and you're the only person who knows what you can and can't do. So let me go over the process with you. First thing, someone has to be convicted of first-degree murder, intentionally murdering someone else with no justification for it. You're not insane, they're not, it's not self-defense, there's nothing, okay? You just killed someone. So the jury has to find that beyond a reasonable doubt. Now there's a penalty phase. The state's going to put on aggravators, the reasons they believe the sentence should be death. The defense is going to put on mitigators, the reasons they believe the sentence should be life without parole. You have to be able to listen to all of that with an open mind, meaning, and you need to process it and internalize it. You can't just sit there thinking, okay, put your evidence on and then I can vote for, you know, life or death, whatever way you're thinking. All right, that's not how it works. You have to actually be open to it. When you go back in that jury room, you're welcome to discuss this all with your fellow jurors, but in the end, it's your decision. So And take as much time to answer this as you need. If you weighed all of these facts, weighed the aggravators, weighed the mitigators, you looked at the instructions, the law in this matter, and you believed that the appropriate sentence was life without parole, could you vote for that?
Yes.
Okay. But if you believed that the appropriate sentence was death, could you vote for that?
Yeah. I guess if push came to shove, maybe. Yes.
Yeah, this is one of those situations where I'm really not trying to put you on the spot.
Yeah. No, I know.
But we need a definitive answer.
Yes.
Because what we can't have happen is that you kind of tell us yes, and then you get to the trial and you go, I can't do this.
Yeah.
Yeah. So do you need a minute to think about it?
Yeah, I don't know if I could.
All right, sir. That's an honest answer. I appreciate it. State.
State moves, Your Honor.
Defense. You may.
You see my little yellow legal pad anywhere? Hello.
Hi.
I want to be clear. No one is suggesting what we're asking of any juror is easy. Sorry. Right? This is probably the hardest thing that will ever be asked of anyone. Right? And so it should be tough. If people come in thinking this is an easy decision, that would be more concerning. I think you'd agree?
Mm-hmm.
Death is never required. Not in any case, not in the worst conceivable case you can imagine. And so the judge went over this, the process in that second part of the trial, right? So the first part is, has the state proven Mr. Lloyd guilty beyond a reasonable doubt, or have we proven him not guilty by reason of insanity? So if they fail to prove him guilty, or we succeed in proving him not guilty by reason of insanity, we don't even get to the part where we talk about penalty, because he's not guilty, right?
Yes.
So if we're in the second part of the trial, you're going to be asked, if you're selected as a juror, to decide some things. The first is, has the state proven the existence of at least one aggravating factor? Okay? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? Reasons for life. And the last question is death the appropriate penalty? And so that's why I think you can see, even if it's yes, 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 you never have to vote yes in that last question. You can always vote no. Does that make sense?
Yes.
And so what the judge is asking you, and in order to be able to serve as a juror on a case where the death penalty is a possibility, is a juror has to be able to give meaningful consideration to both possible penalties for first-degree murder. The life penalty, life without the possibility of parole, or the death penalty. And that doesn't mean just, yeah, I can consider it. It means consider it and potentially do one of the two. Can you give meaningful consideration to both possible penalties?
Yes, I think I could. And then, yes.
Sir, I have nothing further, Your Honor.
All right. State, you may inquire.
How are you, sir?
Good, good.
So I don't want to belabor the point, but given the difficulty you're having with this topic, it's important that we discuss it at length. So you told the court when it comes to the issue of the death penalty that you're not sure that you could ever actually vote for a sentence of death.
Yes.
Do you still feel that way?
I'm torn, you know, it's like, I want to do the right thing, but sometimes, you know, in your heart, you feel like you might not be able to do that to someone, you know what I'm saying, even though it should be the right thing.
Right. Even if you believed it's the right thing, you're not sure you could do that thing. Is that an accurate assessment?
Yes.
All right. So you have, if I'm wrong, tell me, you have a doubt about your ability to do that.
Yes.
And that's based on your moral, did you say moral belief?
Yes, yes.
Now, given that, I think you understand that the law will never tell you that you even should, right?
Yeah.
You will never be required to vote for death if you're selected as a juror. think the defense counsel made that clear. Do you understand that?
Yes, yes.
Given that you would never be required, can you honestly imagine a circumstance where even if you thought it was the right thing, to use your words, you could overcome that moral feeling and vote to impose a sentence of death on another human being?
Objection calls for a pre-commit.
Overrule.
Do you understand the question?
You repeat it again.
Yes, sir. Given that you're never required to vote for death, even if the law authorizes it, knowing that, could you vote to impose a sentence of death on another human being, given your moral belief about that you shouldn't do that? And it's just how you feel, sir.
I would hope I could. I wish I could, yes.
But you're not sure?
Not sure.
Okay.
Yeah.
Been above and beyond trying to be honest with
Yeah.
a difficult topic,
Yeah.
so I appreciate it. That's all I have, Judge. Thank you very much.
Let me see the attorneys at the bench. All right, sir. We appreciate your thoughtfulness, your willingness to serve, and your being here. I'm going to excuse you from this jury. You're free to go.
All right. Sorry, Your Honor.
There's no need for you to apologize, sir, at all. That you have your beliefs, and there's no problem with that.
All right.
We appreciate your being here.
All right. Thank you.
Thank you. All right. Juror in seat 13, but this is panel 9. That was the end of the folks who knew something about the case. I'm now switching to folks who've expressed issues with the death penalty. So it's panel 9, seat 13, 887. God.
In the restroom, Judge.
Okay. Seat 17, panel 9, 532.
Thank you.
Hello, sir. Are you juror number 532?
I didn't hear you.
Are you juror number 532?
Yes.
Okay. We have some questions for you this afternoon. There are no right or wrong answers to these questions. The questions are designed to determine whether or not you would be able to do your job as a juror in this case. It's something that we need to know and you need to know. So the only correct answer is the truth, okay?
Correct.
So you indicated to me that you have a moral, religious, or personal objection to the death penalty. Is that correct?
Correct.
Which one is it?
Religion.
Is it moral, religious, or personal?
Moral religion.
Okay, how long have you held this belief?
How long?
Yes, sir.
Since I've been born.
Okay.
Raised like that.
Is your belief such that no matter what the law, the evidence, or the facts were, you would never be able to impose a sentence of death or vote for a sentence of death?
I don't believe.
You what?
I'm not. No.
Is that a no?
No.
Okay, thank you. State.
State moves.
Defense. All right, sir, thank you very much. You're free to go. If 13 is available, 13, please. Good afternoon, how are you?
I'm good, how are you?
Just well, just fine, thanks. I have some questions for you. The attorneys may have some, but there aren't any right or wrong answers to these questions. What we're trying to find out is whether or not you can do your job as a juror in this type of case. That's why we're asking you these questions. So the only correct answer is the truth. You understand? All right. You indicated to me that you have a personal, moral, or religious objection to the death penalty. Is that correct?
Yes, ma'am.
Which one is it?
Religious.
What religion are you?
Christian.
Okay. And what is your belief about the death penalty?
I just don't think that it's right. I just feel like everybody should be able to have a chance to live.
Okay. So based on that belief, could you ever, regardless of what the law, the evidence, or the facts told you, would you ever be able to vote for a sentence of death?
No.
State.
We move, Your Honor.
Defense. All right. Thank you, sir. You're free to go.
Can I know last week you discussed about like work reasons and
You've been excused.
Oh, okay.
You're free to go. Yeah.
Okay. Thank you.
Sure. No problem.
Down the aisle to the exit.
Let me see, 27's gone. I need this is the flip side, someone who said they would always vote death, I believe. Juror in seat 35, that was the indication. And this is juror 918. Good afternoon, how are you?
I'm good, how are you?
I'm doing well, thank you. So I have a few questions for you. There aren't any right or wrong answers to these questions. The questions are designed to try and figure out whether you can do your job as a juror in this type of case. It's something we need to know, it's something you need to know. So the only correct answer is the truth, okay? You indicated to me that you're a person who has some very strong beliefs about the death penalty, is that correct?
Yes.
All right, in order for the death penalty to even become an option, someone has to have been convicted of first-degree murder, intentionally killing another person with no legal reason for doing so. In other words, it's not self-defense, there's no defense to it. And the jury has to have found that person guilty beyond a reasonable doubt. You with me so far?
Yes.
If you found someone guilty of first-degree murder, as I have defined it to you, would you be able to consider a sentence of life, or would you vote for death?
I would be open to life.
Okay. So when I asked the question about folks who would vote for death, you raised your paddle. Can you tell me why?
So I'm just a person who, it's a life for a life. If found guilty,
okay,
but got to be open-minded as well, I guess. I don't know, I was just sitting back there. It's not black or white.
So your personal belief is a life for a life?
Yes.
Is that a religious or personal belief?
Just personal.
Just personal? How long have you had that belief?
Just the way I was brought up.
Okay. So let me ask you a few follow-up questions on that. If I added to the fact that it's a conviction for first-degree murder, as I defined it to you, and I added to that the fact that it's a law enforcement officer, would that change your answer?
If we're going for
yes, ma'am. Being able to consider life. The person
Yes.
that was killed was a law enforcement officer.
I would be considering life.
All right. And then if I add to that the fact that there's a prior conviction for murder, and that would be of a pregnant woman, would that change your answer?
That would change my answer.
And then what would your answer be?
Sorry. Death penalty, sorry.
Okay. In that circumstance, do you believe you would ever be able to fairly and openly consider life?
No.
State?
Remove, Your Honor.
Defense? All right, thank you, ma'am. You are free to go. We
Thank
appreciate
you.
your service. Yeah, thanks. All right. I don't have anyone else that I made notes on. Does anybody else have that? Because I got a little confused with this one. All right. Nope. In that case, let's try and finish panel number 8. So, I think it's this one. All right, panel 8. Juror in seat 55, juror 51. Good afternoon, ma'am. How are you?
I'm well, thank you, Your Honor. How are you?
I'm doing well, thanks. Look, I know this whole scene is uncomfortable for you. Try and relax. I'm just going to be asking you some questions, and then the attorneys will have some questions for you. There aren't any right or wrong answers to these questions. The questions are designed to try and determine whether or not you could do your job as a juror in this type of case. So the only correct answer to any of these questions is the truth. Just tell us what you actually think and believe, all right?
No problem.
So let me start with, I don't have any notes indicating that you've ever heard about this case prior to coming to this courtroom.
Correct.
All right. Do you have a personal position or belief about the death penalty?
Honestly, I would need more information to be able to make that type of decision.
That is the law, so you're fine so far. So let me ask you some more specific questions. First-degree murder, as I told you, is the intentional killing of another person. You have no legal justification for it. It's not self-defense. You don't have any other defense. You just murdered someone. And the state has proven it beyond a reasonable doubt. That's the first thing that has to happen before a death penalty conversation even occurs, all right? So a jury's convicted someone of that. Is the mere fact that you've convicted someone of first-degree murder, would that alone result in you voting for death?
No.
All right. If I added to that fact that the person that was killed was a police officer, would that change your answer?
No.
And if I added to that fact that the person was guilty of a prior murder of a pregnant woman, would that change your answer?
No.
All right. You heard me describe the process of the penalty phase. Aggravators, mitigators, weigh them. Number one, could you sit through a penalty phase and listen to everyone with an open mind and process the information you're being given?
Yes.
And is there anything about the process of weighing aggravators and mitigators that you believe you would be unable to do?
No.
If that process led you to believe that the appropriate sentence was life without the possibility of parole, could you vote for that?
Yes.
And if it led you to believe death was the appropriate sentence, could you vote for that?
Yes.
Do you have any doubts about any of that?
No.
All right, moving on to the insanity defense. As I told you, it's been raised by the defense. It's their burden to prove it, and it's in the first phase of the case, guilt phase, where you're trying to decide whether or not he's guilty. If at the end of the guilt phase, you've heard all the state's evidence, you've heard all the defense evidence, you were convinced that he was insane at the time this occurred, would you be able to return a verdict of not guilty by reason of insanity?
Potentially.
All right, what do you mean by potentially?
I would have to hear all the facts of that to be able to make that decision.
Oh, I'm not asking you to vote right now. I'm saying assume you've heard all the evidence and you're convinced by it. Would you be able to vote not guilty by reason of insanity? You haven't heard anything right now, okay?
I know. I'm just a very factual person, so it's to make an assumption to say yes to that without knowing all the evidence to it. But if it was an overwhelming evidence of that, then yes, I could vote not guilty.
And then lastly, as I indicated to you, the murder of Ms. Dixon and her unborn child cannot be used by you to decide whether or not Mr. Lloyd's guilty of these charges. It's two separate cases. Can you put that out of your mind during guilt phase?
Yes.
All right, you can use it during the penalty phase as directed, but not during guilt, and you're comfortable with that?
Yes.
All right, thank you, ma'am. I have no further questions for you, but the attorneys do. Mr. Williams, you may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
You have this pained look on your face. It's just try, like the judge said, just try to relax as best you can. And
Oh, it's the mask deal. It's just uncomfortable.
that explains the pain. Do you have some concern generally about the insanity defense? I'm asking because of the nature of your response. So let me give you an example. There are those in our community who think that insanity, as far as defending against a crime, is always an excuse, and that it's very rarely, if ever, actually true. Do you feel that way?
I think mental health is a problem in our society right now that's been overlooked. So I'm not saying that it's not possible.
Okay. But it would be, are you saying that it's difficult for you to fairly consider it? Because and again, I'm reading it, and if I'm wrong, I want you to correct me. In one breath, you're saying you believe that mental illness is real and it's overlooked, but it seems like you're struggling with the willingness to accept an insanity defense if it were proven to you.
If it's proven to me beyond a reasonable doubt, then yes.
That's not the standard, though.
Okay.
The standard that we have, our burden for everything, is beyond a reasonable doubt. They have to prove it by clear and convincing evidence, which is a lower standard. All right? And there's a lengthy definition of clear and convincing evidence, which is why I'm not giving it to you right now. But I can tell you that it's lower than beyond a reasonable doubt.
Okay.
So what I'm just wondering is there something about the defense of insanity that makes you skeptical? Maybe that's the word, that makes you skeptical of it. And there's no wrong answer.
Oh, no, I understand that. No, I mean, if it's clearly proven to me, then I could.
You could find him not guilty of every reason of insanity?
Yes.
Okay. All right. Was there anything about the court's explanation regarding the process for a decision in a capital case that was unclear to you or that you didn't understand?
No.
Do you feel comfortable that you know what your role is or would be if you were selected as a juror when it comes to rendering a verdict on the sentence in the case?
Yes.
All right. My review of your information indicates that the information you filled out indicates that you were a juror in the past. Is that right?
Correct.
How many times?
Once.
Okay, and how long ago was that?
Oh gosh, I was probably in my mid-20s.
I never, ever speculate on a woman's age. So was that a long time ago for you?
I think like 15, 16 years ago.
Okay.
It was when I was still a resident of Osceola County, so it was so long ago I couldn't tell you the year, but I want to say it was early to mid-20s.
Do you remember the nature of it? Was it a criminal charge or was it civil?
DUI was criminal, correct?
It is? Yes, ma'am. Without telling me what the verdict was, did you reach a verdict?
Yes, we reached a verdict.
All right, and were you the foreperson of the jury?
I can't remember if I was or wasn't. It was so long ago. It was
That's okay.
16 years ago, but we did reach a verdict.
Was there anything about that experience, I almost asked if it was memorable because it sounds like it wasn't, but was there anything about that experience that makes you either want to participate as a juror in this case or dissuade you from wanting to participate?
Neither. I mean, I would accept being a juror. I think it's an interesting process. I'm very much a rule follower, so I like that things are typically clear in how to make the decision. What I do for a living, I look at a lot of information and data, and I look at reoccurring themes to help companies create strategic plans.
Okay, and that dovetails into you're a factual person.
Right.
Analysis.
There's no right or wrong. I look at, show me the data.
So if one, regarding your participation as a juror in this case, because this is obviously very different than a DUI, if one is you can't wait to get out of here and do anything but this, and 10 is you can't wait to see your hotel room when you're sequestered, where do you fall on a 1 to 10 scale whether you want to be a juror in this case?
I'm sorry, one was, yes, I want to be a juror.
One is you don't want to be a part of this, you can't wait to get out of here, and 10 is the other.
I would say an 8.
Is that based on your interest in it or something else?
It's the interest in law and understanding how this process works and understanding that, you're innocent until proven guilty.
Okay. Now, you said that you, a couple times now, relating to your employment, that you're a factual person, you want to see the data, right?
Yes.
Now, the key to any juror's participation in this process so that it's fair is that you see the data before you render a decision, which makes sense to most people, but I want to make sure you're on board. Yes?
Yes.
Specifically, the way the process works in sequence is we would present the evidence of those aggravating factors the judge talked about, and then you would listen to or consider the mitigating circumstances, which is anything about Mr. Boyd's life, background, or character that they believe is a reason for a life sentence without the possibility of parole. The question I have, one of the last questions is, could you give meaningful consideration to anything that is presented to you, even if it's something that at the end of the decision-making process you believe is not that weighty or important? Could you meaningfully consider it?
Yes.
All right. Any concerns about your ability to do that?
No.
Is there anything in your life experiences or background that we have not discussed and that you've not told the judge that you think we should know about you, given that we're trying to select the most fair, partial jury for this case? I don't know that there is, but by way of example, sometimes I ask that question and people say, my loved one was the victim of a homicide 20 years ago and it shaped who I am, or anything like that that you can think of.
No.
Usually if there is, it comes to people's mind pretty quick, so that's fair. Thank you very much for your time.
You're welcome.
Thank you, Anna.
No, you may inquire.
Hello.
Hi, how are you?
Oh, I'm great. How are you?
Doing all right, considering.
Yeah, given the circumstances. You work for Correct Craft, correct?
Yes, ma'am.
Correct Craft? That's the boating company, correct?
Correct.
Okay, I just wanted to make sure I understood what the company was. I want to talk to you a little bit more about the insanity defense, okay? Some of the things you said, when the judge asked if you'd be able to find somebody not guilty by reason of insanity, and we're talking about this case, and so it is the murder of a law enforcement officer. And initially you said to the judge if there was overwhelming evidence. Do you remember saying that?
Yes.
And then to Mr. Williams, you said such things as, I'm not saying it's not possible, right? And you guys had the conversation about beyond a reasonable doubt or clear and convincing evidence.
Yep.
And then you ended with it by saying if it was clearly proven to you, right?
Yes.
Okay. So this is tough, and I know there's a lot of burdens, right? So the state, in proving somebody guilty, has to prove that person guilty beyond and to the exclusion of all reasonable doubt.
Okay.
It is really the highest burden you would ever hear as a juror in this courtroom, okay? Clear and convincing evidence is a much lesser standard, and that's to find somebody not guilty even of the crime of murder of a law enforcement officer.
Okay.
All right, and if we're talking not guilty by reason of insanity, we're talking not guilty. And I get that you're a factual person, but I am genuinely asking about your feelings, understanding there's no right or wrong answer, and the only oath you've taken thus far is to tell the truth. So in finding somebody not guilty by reason of insanity, do you think you'd want to have no doubt in making that determination?
Can I have?
Well, and that's where I get that it's confusing, right? But it's, I don't want to like undersell it, but it's almost more likely than not likely. And so this is beyond a reasonable doubt. Clear evidence is down here. And some people say, yep, that's fine. And some people, and again, no right or wrong answers, say if we're talking about finding somebody not guilty by reason of insanity to the crime of murder of a law enforcement officer, I'm going to want to have no doubt that he was insane or very little doubt. But it's going to be a whole lot more than clear and convincing evidence. Does that make sense?
Yes, so you're asking me if I dream of needing it to be clear or if I can go to or level of clear and concise, correct?
Yep, clear and convincing, yes, ma'am.
Yes, I could make the decision on clear and convincing.
Tell me how you got from your initial answers, which were a couple, kind of lending us up here, to this.
I think it's just a hard thing to answer, and from the standpoint of, we know this is a murder trial, right?
Yep.
He had stated, prosecution had stated, you know, that most people think that pleading insanity is the most common thing in a murder trial. So it goes back to me without hearing and understanding, like, I remember the witness list, you know, very well. There's a lot of doctors on there. I'm a very pro-science person. So I would be, I think hearing that and understanding and having friends that I have who've dealt with children who have mental health issues and stuff, yes, I can be clear and I can make a decision on clear and concise. I think it was either one way or the other way, not understanding that there was their side's reasonable doubt, yours is a little bit lower level. So I think the more that you explained it and the more that I've had time to understand it and process it,
yep,
makes me understand, like, okay.
And that's totally fair. That's why I just wanted to ask you some follow-up questions.
No, that's fine. I appreciate you trying to understand the clarity and, me processing that question.
It's a lot. There is this conception that like anybody charged with a serious crime, and this isn't true, but I think a lot of folks think everybody charged with murder pleads not guilty by reason of insanity, right? Oh, it's just an excuse, it's just a cop-out for somebody who got caught for murder. Do you follow?
Yes.
Is that how you feel?
I think that's the given norm in the society when it's done. So I think that kind of shapes my thought on it off the bat, but would I be able to give a fair and equal trial to someone that was doing that? Yes, I would.
Okay. Why do you, and I, again, it's totally fair. Your opinion on this is not, this isn't the first time I've heard it, I promise. Why do you think you could put aside sort of those norms, societal norms that you talk?
Because this is a court of law, and what we are here to listen to the evidence and listen to everything through that and make that decision. Not what's influenced by the outside, not what's influenced by our emotions, but by looking at everything that's given to us on both sides and making the right decision.
Sure. You can appreciate everybody who comes into this courtroom, lawyer, police officer, juror, comes in this courtroom shaped by their own personal life experiences, walks of life, right?
Right.
And that's okay. And so I'm not asking you to do something that's impossible, right? And some people say that they can do this easier than others. It's about finding folks that are the right fit for this case. And it's not like a value judgment on anybody. Does that make sense?
No, I understand that.
And so now I want to talk a little bit about, because you said you wanted to apply the law and you weren't like a feelings person, so to speak, talking about the death penalty, understanding that in order for us to get to the part where we're considering the death penalty, you have found somebody guilty of the intentional, premeditated killing of an innocent victim. Defendant thought about it, meant to do it, and did it. Right? And in this case, it's a law enforcement officer. And so some folks say, if I make that determination that somebody is guilty beyond a reasonable doubt, no legal justification, excuse, or defense of the murder of a law enforcement officer, I really know for me, my feelings, that death is the only appropriate penalty for that person. Does that make sense?
Yes.
How do you feel?
The death penalty is definitely an option, but I would weigh very heavily on that and hearing the other side of that. If there was a clear, if it clearly was insanity, then I could go back to the other sentence, but I'm not going to make that decision until going through and we determine if they're even convicted of first-degree murder. That can't even be an option until the guilt part is done.
Right. And let me be clear, too. If you find somebody not guilty by reason of insanity, again, it's not guilty. We're not going to be talking about penalty. Does that make sense?
Yes.
And so there could still be mental health issues going on that you could consider in the second part as to what the appropriate penalty is, even if you reject the defense of insanity. Does that make sense?
Yes.
Like I said a little bit, so insanity is this narrow legal definition that the judge is going to give you. And you may hear about somebody having mental illness, disease, infirmity, or defect, and say, okay, that doesn't meet the definition, the legal definition of insanity, so I'm going to find this person guilty. But you can still consider those mental health issues in deciding what the appropriate penalty is, life or death. Does that make sense?
Yes.
Okay. Do you think you could consider the effects of racism on the defendant who committed the intentional premeditated murder of a law enforcement? And when I say that, I'm talking about meaningfully consider in a way that you're going to hear it, internalize it, and it could possibly impact your verdict as to life or death, not just hear it and dismiss it sort of simultaneously. Does that make sense? No? You're looking at me looking
Are
great.
you, let me clarify, help me understand if I'm understanding. Are you asking me if I will make a decision based on racism?
No, let me clarify it a little bit.
Okay.
So we talk about mitigating circumstances. We're in the second part of this trial now. You found somebody guilty. We're talking about whether life or death is the appropriate penalty.
Okay.
With me?
Yep.
And you may hear, mitigating circumstances can be absolutely anything from the defendant's character, background, experiences, or even from the case itself. It's fairly unlimited. With me? And so you might hear evidence, if we get to the second part of the trial, about the defendant experiencing the effects of racism. And so I'm asking you if you think you could meaningfully consider that in a way that it could potentially impact your verdict as to life or death, knowing we're still talking about the premeditated murder of a law enforcement officer.
Yes.
Okay. Any hesitation or doubt about that?
No.
Okay. You will be probably not surprised to hear me say that folks have differences of opinions on these sort of things.
I understand.
Okay, and the law totally allows that. And that's why the judge has said this, and I'm going to repeat it, that death is never required, not in any case, not in the worst conceivable case you can imagine, okay? And so if we're in the second part of this trial, where you're deciding what the appropriate penalty is, the steps are, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is that aggravating factor sufficient to warrant the death penalty? Does the aggravation outweigh the mitigation? And the last question is death the appropriate penalty? The answer to that last question is never required to be yes, even if all of the other answers are yes. So if you say, yes, they've proven an aggravator, yes, it's sufficient to warrant the death penalty, yes, the aggravation outweighs the mitigation, you can still vote for life. Make sense?
Yes.
If one juror says that life should be the verdict, then life will be the verdict. Follow me?
Yes.
Because all 12 folks would have to be unanimous.
For the death penalty.
Yep. So if one person, if it's 1 to 11, that's still a life verdict.
Okay.
Okay with that?
Yes.
Mitigation can be absolutely, well, no, let me say this. Mitigation does not have to be unanimous. It can be unique to each individual juror. And again, it can be something seemingly small, a smile between the defendant and a family member. And for a juror, that juror says, I assign the weight of life to that, and I'm not imposing a death penalty in this case. And that's okay. You okay with that?
Yes.
In order for a just verdict to be returned in this case, all 12 individual moral assessments about whether Mr. Lloyd lives or dies have to be heard in this courtroom. That's your duty, your right, and your responsibility as a juror. With me?
Yes.
And so if you're selected as a juror, when you're deliberating, you'll pick a foreperson. In the penalty phase portion, the foreperson writes down the verdict on the verdict form, but really in doing so, that foreperson is saying, this reflects all 12 individual moral assessments of each juror on this jury. With me?
Yes.
You're not going to allow anybody to bully or badger you in your opinion once you've reached that individual moral assessment, right?
Correct.
And you're not going to do that to anybody else.
Correct.
May I have just a moment, Your Honor?
Yes, ma'am.
I have no further questions. Thank you, Madam Judge.
All right, let me see the attorneys at the bench. We'll be right with you, ma'am. You can put the mic down for now. All right, ma'am, we appreciate your time. We appreciate your willingness to serve. I'm going to excuse you from this jury. You're free to go. Thank you. Juror in seat 56, panel 8. This is juror 217. And this is, as far as my notes go, the last remaining juror from this panel. Okay. Good afternoon, sir. How are you?
I'm good. How you doing?
I'm doing all right. I have a few questions for you, and then the lawyers are probably going to have some questions for you. There aren't any right or wrong answers to the questions you're being asked. The questions are being asked in order to see if we can determine, you need to switch, and to see if we can determine whether or not you can do your job as a juror. It's something we need to know, and something you need to know, whether you can do this, all right? So the only correct answer is the truth. Let me start with confirming that you've never heard anything about this case. Is that correct?
That is correct.
And do you have any position on the death penalty?
That's a difficult question to answer in a short amount of time that we have. The reason why I didn't pick up my panel, the initial question, was because I actually needed some time to think about this. And the way to answer that I can fully answer is in a spectrum. I will be leaning towards the fact that all life is precious, and I think that there may be only one entity that can decide between life or death, in my opinion, and that's probably God. So it'll be very difficult for me to be put in a position to make that decision unless I really had to.
Okay, let me break that down a little bit,
Sure.
all right? So is this a personal, moral, or religious belief?
Religious.
All right, what religion are you?
I'm Catholic.
Okay.
I'm Catholic.
And the Catholic Church teaches?
That all life is precious.
Okay, and that the death penalty is wrong. Is that the official
Yes.
position of the Catholic Church? All right. So in these cases, death is never required. I mean, no juror is required to vote for death. But you have to be able to fairly consider a death sentence. And if the evidence, the facts, and your personal beliefs led you to believe that a death sentence was the appropriate one, you have to have the ability to at least consider voting for it, okay? Again, no one's going to tell you you must vote for death if these things happen. It doesn't work that way. But you have to be able to consider it. Both sides have to have a fair shot, basically, all right? So you're the only person who knows yourself and knows the answer to this. You've convicted someone of first-degree murder to even get to this, to get to a penalty phase, as I told you. The state's putting on evidence of aggravators, the reasons they believe death is the appropriate sentence. The defense is putting on evidence of mitigators, the reasons they believe life without parole is the appropriate sentence. You've got to be able to listen to both of them with an open mind and be open to and process the information that they're giving you. You cannot be sitting in the jury box. An open mind doesn't mean you're sitting in the jury box saying, okay, I'll listen, I'll take notes, I'll do everything you're telling me to do, and then I'm going to go back in there and vote for either life or death, because it doesn't matter what anybody says. You follow me?
Yeah.
So once all that's happened, you're going to go back in that jury room. You've got to weigh the aggravators and the mitigators. So I know you've never been in this position, so to the extent that you can, imagine yourself in this position. You've listened to all the evidence. You're back in the jury room. You've gone through it all. You've weighed the aggravators. You've weighed the mitigators. I've given you the law, the jury instructions. After all that process, you believe life without parole is the appropriate sentence. Would you have any trouble voting for that?
No.
All right. How about if you believe the appropriate sentence was death? Could you vote for death?
No.
Okay. Thank you, sir. State.
State moves.
Fence. You may.
Hello.
Hi.
When the judge first asked you about could you impose a death sentence, correct me if I'm wrong, you said probably not unless I really had to.
It would be almost a forceful had to. So I personally would almost feel like as I'm being coerced to do it.
Okay.
It'd be very difficult for me to decide out of my own willing and have it on my conscience to decide between life or death.
Okay. Here's the thing. It shouldn't be easy, right? I mean, I think that would be probably more disturbing if somebody came in and was like, no problem, right?
Correct.
And so what the law requires for you to be able to serve on this jury is to be able to give meaningful consideration to both possible penalties for first-degree murder. Life without the possibility of parole and the death penalty. And when I say meaningfully consider, I don't mean, like the judge said, I heard it, I kind of dismissed the possibility simultaneously of the death penalty, I'm just going to vote for life. It's I'm meaningfully considering it, and that I could see myself potentially, knowing it's not required, doing one or the other. Do you think you could give meaningful consideration to both possible penalties?
No.
Nothing further, no objection.
Thank you. All right, thank you, sir. You're free to go.
Thank
We
you, ma'am.
appreciate you being here today.
Oh, anytime.
Thanks. All right. That concludes panel 8. Panel 9. All right, let me see. I show the juror in seat number 9, juror 176. All right, this gentleman is the gentleman who indicated, we're also going to switch out court reporters. This gentleman is the gentleman who indicated he has some hearing difficulties, so if the attorneys need to remove their masks to question him, please do so. Juror in seat number 9. 176, he's not here yet. Bring him up, please. I'm not going to call him into the courtroom because I haven't instructed him, but get him up here because we don't have that many people left. So we're going to do juror in seat number 25, then juror 106. And I'm going to stop talking so the court reporters can, are you switching? Not yet? Okay. All right. Yes, ma'am. He said it helps if people have, if the witnesses had clear masks on, because lip reading assists him in addition to being able to hear. He's lost hearing in one ear. I think it's the right one. I'm pointing to my left, but I think it's the right, and he has to turn his head.
Does the court have any consideration as to what you would do about the lawyers? So knowing that like none of us are wearing clear masks.
Yeah, I just said, I know it's a dead zone over there where you could barely hear we can't hear you.
No,
and
I
you can't hear
heard that. I meant for trial. Like when we're questioning witnesses.
Yes, and I would solve that problem, but not right this second.
Okay.
Okay? Thank you. What happened to 25? They're the late ones? Well, I forgot who the late ones are. All right, 9, 25, and 37 were late. All right, so give me seat 29. Just give me someone, anyone. So I have 2 back there, 29 and 30. Okay. Wait, I have 3 back there because I have someone from panel 10. Dear God. Good afternoon, sir. How are you?
Doing good.
Are you juror number 849?
Yes, ma'am.
Okay. Give me 1 second to find this. All right, sir. I'm going to be asking you some questions. There aren't any right or wrong answers to the questions I'm going to ask you. The questions are meant to determine whether or not you are able to do your job as a juror in this type of case. It's something we need to know, and frankly, it's something that you need to know. So the only correct answer is the truth. You with me?
Understood.
All right. So let me start by asking you, you didn't indicate that you know anything about this case. Is that correct?
That is correct.
All right. And do you have an opinion about the death penalty or thoughts about it?
I'm personally a little conflicted, but if it is within the means, then it is within means.
Okay. When you say if it's within means, can you tell me what you mean by that, please?
If everything points to it, then it will most likely have to be the case.
All right. In order to do your job as a juror in cases like this, you have to be able to do certain things. So let's go over this in a little bit more detail than what I did before. Let me start with, the first thing that has to happen in any case like this is there has to be a conviction for first-degree murder, meaning the jury has to have found someone guilty beyond a reasonable doubt of intentionally killing another person with no legal basis for it. There's, it's not self-defense, it's not insanity, there's no defense to this. You understand that?
Understood.
All right, so that's step one. Excuse me one second. So, now you're in a penalty phase, right? So let me start by asking you some questions. All that's happened at this point, these are all hypotheticals, all that's happened at this point is you've convicted someone of first-degree murder. Is there anything about that that would cause you to vote for death, hearing nothing else?
Hearing nothing else?
Yes.
No.
Is the fact, if I added that the fact is that it's a police officer who was killed, is there anything about that that would cause you to vote for death, hearing nothing else?
No.
If I add to that there's a previous conviction for the murder of a pregnant woman, would that change your answer?
Yes.
All right. What would your answer be then?
That it would probably be a bit more deserved.
It would what?
It would be more likely.
It would sway you towards death, but would
Yes.
you automatically vote for death just based on that?
No.
All right. After a conviction comes the penalty phase. All right, so now pretend you're in a penalty phase. State's going to put on evidence of aggravators. Defense is going to put on evidence of mitigators. Remember, the aggravators are reasons to vote for death. Mitigators are reasons to vote for life without parole. You have to sit in that chair with an open mind, and an open mind means you're listening to the evidence, you're processing it, you're considering it. Doesn't mean that you have to accept all of it, but you're listening, you're processing and considering. Now you're going back into the jury room to both sides, fairly and openly. You don't stop listening until all the evidence is in. Can you do that?
Potentially, yes.
All right, now you're going back into the jury
Potentially,
room.
yes.
You're going to weigh, I'm going to give you the law, the jury instructions. You're going to weigh those aggravators and those mitigators as I explained to you. At the end of that process, you personally have reached the conclusion that the appropriate sentence is life without the possibility of parole. Can you vote for that?
I'm sorry?
Can you vote for life without the possibility of parole?
Potentially, if the evidence leads to, if the mitigators mitigate the aggravators.
Okay. And if after that whole process you believe the appropriate sentence was death, can you vote for that?
If the aggravators outweigh the mitigators, yes.
Okay. Any doubt in your mind about your ability to go through any portion of that process?
No.
The insanity defense. As I told you, Mr. Lloyd has raised that. It is the defense's burden to prove it in the guilt phase when you're trying to determine whether or not he's guilty. If at the end of all the evidence, the state's evidence, the defense's evidence, it's the end of the guilt phase, you believe the defense has convinced you that Mr. Lloyd was insane at the time, would you be able to return a verdict of not guilty by reason of insanity?
If they could prove that.
Okay. And then lastly, the murder of Miss Dixon and her unborn child, you cannot consider that in determining whether or not he's guilty of these charges. Do you understand that?
Yes, ma'am.
Can you put that out of your mind when you're trying to decide whether he's guilty or not?
During the guilty phase, of course.
Yeah. You can consider it during penalty, but not during guilt. And you're okay with that? All right, thank you, sir. I don't have any other questions for you. The state probably does. Mr. Buxman, you may inquire.
Good afternoon, sir.
Good afternoon.
I want to start by asking you a few questions about the insanity issue. That's an issue that's going to be addressed in the guilt phase of the trial. Part of the trial is to determine whether or not the defendant committed these crimes.
Correct.
Because insanity involves potential mental health issues, I'm going to just ask you a couple personal questions about whether you or a close friend or family member has ever dealt with or experienced mental health issues.
That is fair. Yes.
I'm sorry, I didn't hear you.
Yes, sir.
Okay. Close friend, family member, I'm not looking for names, just relationships.
Few friends.
A friend?
Few friends, yes.
Okay. Were you present with that person while they were going through whatever issues it was?
Yes, sir.
Did that person get help, treatment of some form?
Yes, they had medication.
Yeah, speak up a little bit for the court.
They had medication.
Okay. Based on that, I'm gathering that you are one of the people in the world that realizes mental health is actually a real thing in some people in society.
Yes, sir.
Okay, because some people don't think like that, but you're not one of those people, correct?
No, sir.
All right. Would you be able to listen to all of the evidence relating to whether there is a mental health issue in this case? And if so, what the effects or ramifications of that mental health issue is before you make an ultimate decision of whether or not the defense has proven to you that insanity is a defense case?
I'm sorry, if you could repeat that?
Sure. Basically, can you keep an open mind and wait to listen to all of the evidence regarding whether there's a mental health issue in this case, and if there is, what the consequences of that issue is before you make a final decision?
Yes, sir.
Okay. Shifting gears a little bit to the penalty phase now. For purposes of these questions, we're going to assume that the jury has already determined the defendant is guilty beyond a reasonable doubt of the murder in this case, which means the jury has rejected any defenses, rejected any insanity defense, and found him guilty. Okay? The focus of these questions is basically to determine whether or not you can keep an open mind and listen to all of the evidence. The state will present evidence of aggravating factors, and the judge has alluded to a couple of them already. And aggravating factors are just those factors that make this murder more egregious or worse than other murders. So we've talked about the fact that the victim in this case is a law enforcement officer, which is an aggravating factor in Florida that you could consider, if proven, to lean your decision towards the death penalty. So is the fact that he has been convicted of a prior murder. That's an aggravating factor that you could consider and give weight to determine what the proper sentence is. So my question is, if assuming that you have found, proven to you beyond a reasonable doubt that the victim was a law enforcement officer and that he committed a prior murder, those things might tend to start your pendulum swinging towards the death side of the proper sentence.
Yes,
Make sense? No matter how far that pendulum swings, with all the aggravating factors and all the evidence pertaining to them, could you always wait and listen to the mitigating evidence presented by the defense? Evidence about the defendant's background and upbringing and things like that before you make a final decision in this case?
Yes, sir.
Okay. Can you do that regardless of what piece of evidence or what mitigation is presented to you? Could you consider it all no matter what it is?
Yes, sir.
Okay. Even if this is not the time to talk about the details or the actual pieces of evidence that you're going to hear, that's during the trial. So even if at first blush you're told about something that could potentially be a mitigator, and then your first thought is, I don't think that's mitigating, can you hold off judgment until you hear the details surrounding it and the evidence about it?
Yes, sir.
Okay. Once you hear that evidence, then you're going to go through the process of weighing the aggravating factors and mitigating circumstances to determine what the proper punishment in this case should be. When you first started talking with the judge, you said that you were conflicted about the death penalty.
Yes, sir.
Can you explain to me a little bit about what you meant?
I'm a little conflicted because I don't exactly know how I feel about voting for a man to potentially be executed.
Okay.
I don't know how to weigh upon myself.
Okay.
I don't have I've never had that experience before.
It's obviously, it's a heavy, weighty thing to consider and to be involved in, sure. Let me follow up on that a little bit. If after you, well, first of all, the judge indicated that there's nothing that will ever require you to vote for the death penalty in this case.
Correct.
You're not going to be in a position where if you check these 5 boxes, then you have to vote for the death penalty. That make sense?
Yes, sir.
Is going to be completely up to you and the other individual jurors what your opinion of the proper punishment should be in this case. If you find yourself back in that jury room, and after you've done this weighing process and considered all of the evidence, you felt that life in prison was the proper punishment, could you vote for that?
If I found it to be the proper punishment, then yes, I could vote for that.
Okay. On the flip side of the coin, if you're back there, and we're not talking a hypothetical situation where you're hanging out with friends and talking about the death penalty and saying, yeah, I could vote for death on that person. We're talking a real life situation. If you found yourself back there, you've weighed all the evidence, you've mulled it all over, and you in your heart had determined that the death penalty is the proper punishment in this case, knowing that you're never required to vote for death, would you be able to raise your hand and say, I believe that this man deserves to die for what he did?
Overruled.
Only you know that question. That's something you have to look deep inside yourself to see if you think you can do that. I'm going to give you a second. I'm going to check my notes real quick, okay?
If the jury in the deliberation room has decided that we've all unanimously decided that the proper punishment is death, then yes, I could vote for that.
Okay. And he said if the jury decided it, remember, this is your individual decision. Not the rest of the jurors say. This is all in you.
If everything points, if the aggravators are more heinous than the mitigators, then yes, I could potentially vote for death.
Okay. Any concern, any doubt in your mind, you could do it if you felt that was the right decision?
Yes.
Okay. Is there anything in your background, your life, your experiences, your belief system that may make you think I might not be a good juror for this type of a case? I'm not saying there is, I'm just asking.
Inexperience, but that's about it, honestly.
You experienced what?
Inexperience.
Inexperience, okay. Well, I can probably assure you that no one else has ever been in this situation either. So you're doing fine. I have 1 moment, Your Honor.
Yes, sir.
Thank you, sir. No further questions, Your Honor.
Thank you, Mr. Buxton. You know we're moving far.
Hello.
Hello.
How are you?
Doing good.
You've taken an oath to answer truthfully, so you had to think about that one. I want to just ask you a couple clarifying questions, okay?
Of course.
So in order for us to even be talking about possible penalties for first-degree murder, life without the possibility of parole, or the death penalty, a defendant would have to be found guilty, right? The judge asked you some of these questions.
Correct.
And so the crime of first-degree murder is the intentional, premeditated killing of an innocent victim. The defendant thought about it, he meant to do it, and he did it.
Correct.
And if a jury found that person guilty, that jury would have rejected or eliminated any defense available to that person. With me?
Yes.
So we're talking about premeditated, intentional murder without any legal justification, excuse, or defense. And when the judge asked you, you initially said death would not be the automatic or only penalty for you for someone guilty of that crime. Is that correct?
Correct.
Okay. You can appreciate some people think that if you've committed the crime of premeditated, intentionally killing somebody, the only penalty is really the death penalty. With me?
Yes, ma'am.
Does that make sense? That people have differing opinions on this.
Absolutely.
And then the judge asked you about law enforcement. If the victim was a law enforcement officer, would death, and we're talking about the intentional premeditated killing of a law enforcement officer without legal justification, excuse, or defense, would the death penalty be the only appropriate penalty for that person?
No.
Okay, and then here's where I have some confusion, because when the judge asked you about if that defendant, same circumstances, had been previously convicted of the murder of a pregnant woman, your answer was yes. Do you remember saying that?
Yes, ma'am.
What were you saying yes to?
It was more or less because he murdered someone else before. It wasn't the first time.
Right.
So I think that's more egregious.
Yep. And I think that's fair. I think a lot of people feel that. The question is death the only appropriate penalty for somebody who commits the second murder, who's been previously convicted of another murder and is serving life without the possibility of parole? Does that make sense? Like, I'm asking if you could still consider life as a penalty for this second murder, knowing he's already doing life.
It'd be a bit trickier, but it is potential that I could think about it.
Okay, so correct me if I'm wrong, you said it would be a bit trickier.
Yes, it would weigh a bit more heavier on me. I would lean more one way than the other.
Okay, and again, the aggravators are intended to do that. The mitigators are intended to bring you back towards life.
Right.
So the question isn't, would it make you lean more towards death? It's, is death the only choice? Do you understand the distinction?
Yes.
If you could give me that answer.
Yes, no. It would not be the only choice.
Okay, and let me clarify one thing too. So if we're in the second part of this trial, right, we only get to this penalty phase if the state has proven Mr. Lloyd guilty beyond a reasonable doubt of the crime of first-degree murder, or if we have failed to prove that he's not guilty by reason of insanity. If either of those things, if they fail to prove him guilty or we succeed in proving him not guilty, we're done. He's not guilty, right?
Correct.
So if we're in the second part of that trial and we're talking about penalty, with me? The steps are, in this penalty, has the state proven the existence of at least one aggravating factor beyond a reasonable doubt? Is the aggravator sufficient to warrant death? Do the aggravating factors outweigh the mitigating circumstances? And then the last question is death the appropriate penalty? And that last question is never required to be yes, even if all the other answers are yes. So you could say, yes, they proved an aggravator. Yes, it's sufficient to warrant the death penalty. Yes, the aggravators definitely outweigh the mitigators, but I'm still not voting for death in this case. Does that make sense?
It does.
Because you had said before, when you were talking about could you vote for life or death, you were like, yes, I could vote for life if the mitigators outweighed the aggravators.
Correct.
Remember? And you said I could vote for death if the aggravation outweighed the mitigation.
Correct.
Okay, and that's the law. The question is, could you still contemplate a life sentence even if the aggravation outweighed the mitigation?
It would depend on the weight of the aggravators and the weight of the mitigators.
Okay. You get to decide as a juror what weight you assign to any factor, aggravating or mitigating.
Correct.
And that's where it is an individual moral assessment. I do agree with Mr. Buxman. This one's on you. With me?
Yes, sir.
And so some of the aggravators are huge. It's the murder of a law enforcement officer, a prior conviction for murder of a pregnant woman. And the mitigation can be something like the effects of racism on the defendant. Do you think you could give meaningful consideration to something like the effects of racism on the defendant given the totality of the circumstances? And when I say meaningful consideration, I don't mean I heard it and I kind of dismissed it as I heard it.
I'd have to hear all the evidence.
Okay, but is that something you could give meaningful consideration to?
Yes.
Okay. Just to reiterate a couple of the points that you've already heard, death is not required. With me? Not in any case, not in the worst imaginable case you can conceive of. If one juror votes for life, then the verdict will be life, right? The law gives tremendous power to the individual juror. With me? You have to say it out loud.
Yes, ma'am.
Okay. Mitigation, as we've already discussed, is just why any one juror would choose life or not choose death. It can be unique to each individual juror, and it can be, on its face, seemingly small, and still a juror can assign the weight of life to it. As an example, a juror could say, I observed a smile between the defendant and a family member, and I'm giving that the weight of life, and I'm not voting for the death penalty in this case. Does that make sense?
Yes, ma'am.
You seemed a little hesitant. Tell me what you're thinking,
I was
please.
trying to recap what you said.
Okay, I know, I talk a lot. Sometimes in the deliberation room, things can be contentious. People have strong opinions that often differ on these sort of things. Fair?
Absolutely.
And so what the law requires in order for it to be a just verdict as to penalty, that all 12 jurors' individual moral assessments about whether Mr. Lloyd lives or dies have to be heard in this courtroom. That is your duty, your right, and your responsibility. With me?
Yes, ma'am.
It would be a miscarriage of justice if somebody's individual moral assessment on that jury wasn't reflected in the verdict. Does that make sense?
Yes, ma'am.
Okay. And so you are not going to allow anybody to bully or badger you into changing your opinion if you've reached an individual moral assessment.
No, ma'am.
You're certainly not going to bully or badger anybody else to agree with you, right?
No, ma'am.
In fact, if you've reached an individual moral assessment that the verdict should be life, and you don't feel like it's being respected by your fellow jurors, you can be like, we're done. I've reached a verdict. It's life. Deputy, please get the judge. We can go home now. Do you think you can do that?
Yes, ma'am, if I feel that way.
Okay, and so that's what, you're a little bit of a soft-spoken person, but you have to make sure, and here's what's great, too, because we talk about deliberating, right? Mm-hmm. And we encourage people to hash it out, but you don't have to. Mm-hmm. If you've reached an individual moral assessment, you can, for life, and you can say, hey, listen, I can't explain it, I can't articulate it, I just know in my gut, in my heart of hearts, that the verdict is life, and that's okay too. Okay? Yes?
Yes, ma'am.
Okay. May I have just a moment, Your Honor?
Yes, ma'am.
I have no further questions. I do have a question.
All right, let me see the attorneys. We'll be right with you, sir. You can relax. All right, sir, we appreciate your time and attention. I'm going to excuse you as a juror in this case. You are free to go. Thank you so much.
Thank you, Conley.
You switching out, or you want to keep going? You switching? You're. All right, we're switching. We can. When you come back, you need to log back into Bridge. Are you Markeith capital or Markeith lowercase? Cap? All right, let's go back on the record on State versus Lloyd. He's present with his attorneys. The State Attorney's Office is present. Juror in seat number 30, panel 9. This is juror number 922. Good afternoon.
Good afternoon.
Let me take this off. How are you doing?
Very well, thank you. And you?
I'm fine, thank you, ma'am. All right, I'm going to be asking you some questions, and then the attorneys will have some questions for you. There aren't any right or wrong answers to these questions, ma'am. The questions are designed to try and determine whether or not you can do your job as a juror in this type of case. So the only correct answer is the truth, okay? So let me start by confirming that you've never heard anything about this case?
Not until today.
All right. Do you have any thoughts or position on the death penalty?
That's a hard question to answer. I think in some cases it would be warranted, but I would have to have more information on any particular case.
All right, and that, I mean, that is Florida law. You can't just announce, we don't have automatic death penalties, so. Let me ask you some specific questions about, again, this is all the death penalty. We'll get to other things in a second. As I told you, in order to get to even considering a death penalty, a jury has to have convicted someone beyond a reasonable doubt of first-degree murder, intentionally killing another person with having no legal reason to do so. It's not self-defense, you're not insane, you just killed someone, and that's first-degree murder. So a jury's convicted someone of that. So is that alone for you enough for you to say, I'm going to vote death?
Yes.
I would have to know under what circumstances.
Well, that's part of, when you say under what circumstances, what do you mean by that?
Well, I would have to know more information of what happened, but yes, my answer would be yes.
Okay, so what I'm trying to find out, and do not let me put words in your mouth, all right, is, as I told you, there's a penalty phase that follows a conviction for first-degree murder, and you have to have an open mind during that penalty phase. You have to be open to, and by open, I mean genuinely open. You're actually listening to everything, you're processing information, you're thinking about it and weighing it, and you have to be genuinely open to either life without parole or death. So the question that I'm asking you is, if all you have is there's a conviction for first-degree murder, are you someone who's sitting there thinking, I think that alone warrants the death penalty with nothing else? Just that conviction and, of course, whatever facts you heard during that trial?
Yes.
Okay. So if I add to that that the person who died was a police officer, would that change your answer, make the answer more firm? Would it have any effect on your answer?
No, they would still be a person.
Okay. And if I added to that the fact that the person had a prior conviction for murder of a pregnant woman, what effect would that have on your answer?
None.
None? Okay.
No.
So do you believe that you could go through the process that I've described of there's a conviction for first-degree murder, now you're in a penalty phase, you've got to be open to all this information and openly and fairly consider life without the possibility of parole? Do you think you could do that, or would you be someone who would be thinking, I've convicted this person, I'm going to vote for death?
I would keep an open mind during the whole process, and if I felt that I had to, again, I would have to just have more information, but yeah, I would keep an open mind.
Okay. I think I'm confusing you, okay? And I'm not trying to. but sometimes I do confuse people without meaning to. So let me try this again. You convicted someone of first-degree murder, intentionally killing another person.
Okay.
Now there's a penalty phase. If you're sitting in that jury chair and the penalty phase has started, the state's going to put on evidence of aggravators, reasons they believe the death penalty is the appropriate sentence. The defense is going to put on evidence of mitigators, reasons they believe life in prison without parole is the appropriate sentence. Okay? Can you listen to that evidence with an open mind? And by that, I mean, can you listen to it, process it, genuinely be open to what you're hearing in court?
Yes.
All right. Then you're going to go back in the jury room with all of that evidence at the end and the instructions on the law by me. You're going to be weighing those aggravators and mitigators, assigning importance to them, as we told you. What's important to you, what isn't? At the end of that process, if you believed that the appropriate sentence was life in prison without the possibility of parole, could you vote for that?
Yes.
And if you believed the appropriate sentence was death, could you vote for that?
Yes.
So would you automatically vote for life or death in a case like this? Or would you, do you understand there's a difference in thinking about things, going through the process, or just saying, if I convict someone of this, I'm voting for death?
I can't, if I felt that I had to do it, I would.
All right. The law in Florida never requires you to vote for death.
Right.
Okay? There's not going to be a single jury instruction that says, if all these things happened, you are required to vote for death. You understand that?
Yes.
You just have to be able to consider both death and life.
Yes.
All right. And you can do that.
Yes.
All right. The insanity defense. Mr. Lloyd has raised the insanity defense. The defense has to prove it by clear and convincing evidence. It's a lower standard than reasonable doubt.
Okay.
But if at the end of the guilt phase, this is when you're determining whether he's guilty or not. If at the end of the guilt phase, pretend you were convinced that he was insane, would you be able to vote for not guilty by reason of insanity? All right. And then my last question to you is, I told you that he's previously been convicted of the murder of Miss Dixon and her unborn child. You cannot use that to determine whether or not he's guilty. Can you put that out of your mind during the guilt phase? You can use it during penalty, but not during guilt. All right. Thank you, ma'am. I don't have any other questions. State, you may inquire. Mr. Buffer.
Good evening, ma'am.
Hi.
The first couple questions I have deal with the insanity issue. And that is something that the judge indicated is going to be talked about during the first part of the case, the guilt phase, the part of the case that is designed to determine if the defendant is guilty of the crimes. Because insanity inherently involves a mental health aspects, I'm going to ask a couple personal questions of you, and I hope you don't mind. I apologize. Have either you or a close friend or family member had any experience with mental health issues?
My nephew is schizophrenic.
Okay. Have you been around your nephew while he's been going through those issues?
Yes.
Has he sought treatment or some sort?
Yes.
Has it helped?
Yes.
Okay. Would you be able to keep an open mind and listen to all of the evidence surrounding the mental health issues and the insanity defense before you come to a conclusion as to whether or not the defense has proven it to you?
Yes.
Okay. Shifting to the sentencing phase of this. For purposes of these questions, I'm going to ask you to assume that the jury has already found the defendant guilty beyond a reasonable doubt of the first-degree murder crime. The jury has rejected the insanity defense, found it wasn't appropriate, and we're now into a penalty phase, okay? The whole purpose of this phase is to determine whether or not what the proper punishment should be, either life or death. The state will, that this process while we're talking is not the time to discuss the actual pieces of evidence and the details of the aggravating factors and mitigating circumstances. That's for the trial. So we're not going to get into all the specifics of what you may hear if you're selected for this jury. But the state will present evidence of aggravating factors. Those are factors that make this murder more egregious or worse than other murders. Those aggravating factors, after you hear the details of them, may turn out, and if it's proven beyond a reasonable doubt, they may turn out to be very important to you. Could be some importance, could be a lot of importance. But those aggravating factors, after you hear them, may cause the pendulum of your decision-making process to go towards the death penalty. No matter how far it goes towards the death penalty, are you willing and able to listen to any of the mitigation evidence, all of the mitigation evidence that the defense presents?
Yes.
Okay. Are you able to, no matter what piece of mitigation evidence is presented to you, are you able to listen, think about it, look at the evidence that's presented that deals with each of those pieces of evidence, mull it over before you make an ultimate decision on what the proper punishment should be?
Yes.
All right. Can you do that even if at first blush, when it's presented to you, you may be thinking, I don't really think that's mitigating? Can you hold off judgment until you hear the actual details?
Yes.
Okay. Once you go through that weighing process, you decide how much importance to give all this different information to you, and it could be different for each juror. You then are going to have to make a decision as far as what the proper punishment should be. And I believe when you were talking to the judge, you said something to the effect of, if you felt the death penalty was the appropriate penalty in this case, you could vote for it if you had to. The judge told you that the law never says you have to vote for the death penalty. Does that make sense?
Yes.
Okay, so when you said if I would vote for it if I had to, kind of walk me through what you were thinking when you said that.
I suppose if I looked at the facts that were presented and also what the law required, and if the facts that were presented met the criteria of what the law stated, then yes, I would.
Okay. The law is never going to tell you that you have to vote for death. You're not going to have a checklist back there and say, if you check off these boxes, then you have to vote for death. It's always going to be your decision.
Okay.
Okay, so it's always going to be your individual decision of what the proper punishment should be. Does that make sense?
Okay, yes.
Knowing that it is always your decision and that you never have to vote for the death penalty. If you find yourself back in the jury room, and I'm talking a real life situation, you're here, not a hypothetical hanging out with friends talking about the death penalty, but you're actually here.
Right.
And the law never requires you to vote for death. Would you be able to raise your hand in that jury room and say, come and say, this man, if you find that the evidence and all the facts leads you to believe the death penalty is the proper punishment, could you raise your hand and say, I vote for death, I think this man deserves to die for what he did?
If the evidence and the facts convinced me that yes.
Okay. Likewise, if you felt that the evidence and facts convinced you that life was the proper punishment, could you vote for that too?
Yes.
Is there anything in your background, your belief system, your experiences that makes you think maybe I'm not a good juror for this kind of a case? I'm not saying there is, I'm just asking.
Not that I can think of.
Okay. Can I have one moment, Your Honor? Thank you so much for your time, ma'am. No further questions, Your Honor.
Thank you, Mr. Braxton. Ms. Miller.
Hello.
Hi.
I just want to clarify something you said to Judge Marquez, okay? I want to, so we're on the same page, because we've never met, so I want to make sure I'm understanding you. Premeditated first-degree murder in Florida is defined as the intentional premeditated killing of an innocent victim. That defendant thought about it, he meant to do it, and he did it. With me?
Yes.
If a jury found a defendant guilty of that crime, a jury would have considered any defenses available to that person, like the judge talked about, insanity, self-defense. But in finding him guilty of intentionally and in a premeditated design killing someone, that jury would have rejected any of those defenses. And so for you, I'm asking you as a person what your feelings are. Is death the only appropriate penalty for the person that's guilty of that crime?
No.
Why not?
I would have to know the circumstances of what happened.
Okay. And that's sort of almost the exact answer the judge gave you, or you gave the judge, excuse me. And the judge's question was, tell me what you mean by circumstances. I'm asking the exact same thing.
I guess the details of what happened, I don't know any of the details. Before today, I hadn't heard any of this, so I don't really know. I guess in answer to your question, I'm willing to listen to everything before. I can't give you an answer without knowing more information. In other words, I want to listen to what everybody has to say, and then I can answer your question. But yeah, I would either way. I'm trying to keep an open mind, so I can't give you a definitive answer, yes or no.
Okay. And here's where I'm going with this, right? Some people say, I want to follow the judge's laws and the rules, but for me, my feelings, not talking about the law, is that somebody who's guilty of first-degree murder deserves the death penalty, right? So that's where it wouldn't be fair if we didn't know how you felt and you wound up on the jury and you were like, oh man, I really do think everybody who's guilty of murder deserves the death penalty.
No, that's not true. No, not everybody who is guilty of murder deserves the death penalty.
Okay, how about the murder of a police officer? Is everybody who kills a police officer in an intentional, premeditated way without legal justification, excuse, or defense, in that scenario, is death the only appropriate penalty?
No, I don't know, no.
Okay. And Mr. Buxman talked about this when you said, I want to hear from everybody.
Right.
This is an individual moral assessment. This is your call. Nobody else is going to be able to tell you the right answer to a question like, do I think this person should live or die?
Right. Well, you're speaking in absolutes. Does everybody who kills a police officer deserve the death penalty? No, not everybody.
Okay. How about if you hear the defendant has a prior conviction for murder of a pregnant woman and is serving life without the possibility of parole? Now, is death the only appropriate penalty?
No, because that was a prior conviction, and that wouldn't have anything to do with the current case.
And you are doing great at reciting what the judge told you.
Right.
But it's not allowed to have anything to do with your verdict as to guilt, right? Whether or not somebody's guilty of some other crime really has nothing to do with whether or not he's guilty of this crime.
Right.
It does have something to do with what the appropriate penalty is, okay? Does that make sense? Some people say to me, if I know, we're in the second part of the trial,
right,
where you're deciding the penalty,
right,
and if I know, I've just found this person guilty of murder, and I know that he's already serving life for another murder, that really death is the only appropriate penalty. Does that make sense?
Yeah.
How do you feel?
I'd really have to think about it. But I can't say that would be the only. I hate to speak in absolutes. That's the. I don't know. I don't know.
The state asked you some questions about mental health. Do you think mental health or people truly suffer from mental illness?
Yes.
I want to ask you about something a little bit, same question, different topic. Do you you think racism is real in the sense that it can affect the direction of someone's life?
Yes.
Do you think that you would be able to consider in a meaningful way, think about it, internalize it, and potentially it affect your verdict, the effects of racism on a defendant who is guilty of the intentional premeditated murder of a law enforcement officer?
Would I consider it?
Could you be open to giving that meaningful consideration?
Yeah.
Okay. You would not be surprised, I suspect, to know that folks have differing opinions on these sort of things.
Mm-hmm.
Right?
Mm-hmm.
Is that a yes?
Yes, sorry.
And that's okay. Right? The law, in order for a just verdict to be returned, all 12 jurors' individual moral assessments as to whether Mr. Lloyd lives or dies have to be heard in this courtroom.
Yeah.
And so you're not going to bully or badger anybody to agree with you if they have a differing opinion, right?
Right.
And you would not allow anyone to do that to you, correct?
Correct.
May I have just a moment, Your Honor?
Yes, ma'am.
Don't have any more questions.
Okay. Either side need to approach?
No, Your Honor.
I just have one moment.
Okay. Ma'am, your juror number's 922, right? Is your juror number 922?
I'm sorry?
Is your juror number 922?
Yes.
Okay.
Yes.
Sorry. Yes. Ready? All right, ma'am. Let me take this off so you can hear me. We're going to send you through for a final round of questioning. That round, we will be picking the jury that day. It's going to be next week, all right? So you need to call Friday after 5. We're going to give you a packet. It's got a slip of paper in there with a phone number that's going to tell you what number to call. Call that number. You're going to listen for the recording that says the purple dots, because we're changing your color to purple. The purple dots are to report on such and such a date at such and such a time. When you report that day, we will be picking the jury that day and sequestering the jury that day. So you're going to need to have packed a suitcase. If you're picked, leave it in your car. If you're picked, we'll have you go get it. If you're not, obviously you can just go home. There's also a sequestration package in here that explains to you what it's like being sequestered, what the rules are, what to expect, and gives you a list of things that we suggest you pack. All right? There are laundry facilities. Somebody asked me this earlier, so I'm going to tell you there are laundry facilities, so you don't have to pack for 3 weeks, unless you want to, but you only have to pack for a week or so, all right? But all the instructions are in there. And lastly, we have a letter for your employer indicating that you are returning for jury services. But it doesn't give a date because we don't know yet, but it'll be next week, all right? Do you have any questions, ma'am?
No.
All right, thank you so much. Have a good evening.
Thank you. You too.
All right, from panel number 10, the last juror I have who's been instructed is seat number 3, please. And then we have 3 jurors that we'll be returning to in panel 9 who weren't here for the instructions. Whose number? Oh, I haven't said it yet because I've got a dot covering it. Hold on. This is juror number 598. Good afternoon. How are you?
I'm good, and you?
Good, thanks. You are juror number 598, right?
Yes, ma'am.
Okay. We have some questions for you, all right? I'm going to start, and then the lawyers will have some questions. There aren't any right or wrong answers to these questions. There's no pressure. There's no right or wrong answer. The questions are designed to determine whether or not it's for all of us, including you, to figure out whether or not you can do your job in this type of a case, all right? Yes. So the only correct answer is the truth.
Yes.
So let's get started. Number 1, I'm confirming that you've never heard anything about this case. Is that correct?
That is correct.
All right. And you work for a law firm in Kissimmee, correct?
For now, yes.
For now?
I will be leaving because the drive is a little much on me.
I understand. That law firm, as I understand it, does not do criminal law. Is that correct?
That is correct. They do real estate, probate, and estate planning.
All right. Do you have any beliefs or position about the death penalty?
Not really.
Okay.
If it's warranted, then it's warranted.
All right. Are you someone who believes the death penalty should be automatically imposed if someone is convicted of first-degree murder?
No, ma'am.
And you know first-degree murder is the premeditated killing of another person with no legal justification for it.
Yes.
Okay. And that's the first thing that has to happen before there's even a discussion about the death penalty being a possibility. Death is never mandatory in the state of Florida. So let me add some facts to conviction on first-degree murder. If that conviction is for the death of a police officer, would you be someone who would automatically vote for death without hearing anything else?
No, I'd have to know what the circumstances were.
All right. And if you were told that there's a prior conviction for the murder of a pregnant woman, would that cause your answer to change?
No, ma'am.
You heard me describe what the process is, the penalty phase, the aggravators, the mitigators. Got to listen with an open mind. Do you think you would be able to listen to both sides with an open mind?
Yes, ma'am.
And do you think you would be able to weigh those aggravators and mitigators as I explained?
Yes, ma'am.
If that led you to believe that the appropriate sentence was life without parole, would you vote for that?
Yes, ma'am.
If it led you to believe that death was the appropriate sentence, would you vote for that?
Yes, ma'am.
Let's switch gears to the insanity defense. Defense has to prove it by clear and convincing evidence. It's a lower standard than the state standard of reasonable doubt. Pretend it's the end of the guilt phase. You're trying to decide whether he's guilty or not. Defense has convinced you he was insane at the time of the offense. Would you return a verdict of not guilty by reason of insanity?
I'm not sure.
Okay. What's causing you to hesitate?
I guess not knowing the full circumstance.
Oh, I'm not asking you to commit to anything.
Yeah.
This is pretending, all right?
Yeah.
We're pretending. So these are hypotheticals, ma'am, all right? You haven't heard anything.
Right.
All right? So I'm asking you to assume that at the end of all the evidence, the defense has put theirs on, the state's put theirs on, but at the end of that evidence, you are convinced by the evidence that he was insane at the time. Would you be able to return a verdict of not guilty by reason of insanity?
Yes.
Okay. Do you have any doubt about that?
No.
All right. And then lastly, as I told you, the murder of Miss Dixon and her unborn child, you can't use that to determine whether he's guilty or not of these charges. That only becomes relevant if we get to a penalty phase. Can you put that out of your mind during a guilt phase?
Yes.
All right. Thank you, ma'am. I don't have any other questions for you. State and defense will. Mr. Buxman, you may inquire.
Thank you. Good evening, ma'am. How long have you worked at that law firm?
Mid-June of this year.
Are you going into the similar field on a different location, or are you switching careers?
Switching careers.
Okay. Couple questions about the insanity issue. You have a really long pause, but I'm assuming that was cleared up when you realized the question was, if you have to listen, can you listen to all the evidence, and if the evidence convinced you the defense had been proven of insanity, could you vote that way? And you could.
Yes.
Understood. Have you or a close friend, family member, somebody close in your life had any experience with mental health issues?
Yes.
Okay. I'm not asking you to tell me a name of a person, but can you give me an idea of the relationship of that person to you?
Close family, sibling.
Were you present while that sibling was going through that mental health issue?
I was very young.
Okay. Do you know if that person has sought treatment, medication, therapy of some
Yes.
sort? Has it helped?
Yes.
Wonderful. Okay. Shifting gears to penalty phase.
Okay.
And these questions are assuming that the jury has already heard the evidence for the first part of the trial, the guilt phase. The jury has determined that the defendant is guilty beyond a reasonable doubt of first-degree murder. They've rejected insanity as a defense, and they found him guilty.
Okay.
Okay? I have a couple questions about the death penalty, or the sentencing process. This is not the time for us to talk about the specific details or what evidence you're going to hear about aggravating factors and mitigating circumstances. That's later. So I'm going to ask you some generalities. You have heard from the judge that the victim in this case was a law enforcement officer.
Yeah.
That is an aggravating factor. You've also heard that the defendant was convicted of a prior murder. That is also an aggravating factor in Florida. Now, you can't use that in the guilt phase to determine if he committed the crime, but assuming you've determined he committed the crime and found him guilty, it may come into play in the sentence phase.
Okay.
So if you hear these evidence of these aggravating factors and they're proven to you beyond a reasonable doubt, some of those aggravating factors may start causing your death penalty, your pendulum, to start swinging towards the death penalty because these aggravating factors are, swinging over this direction. My question is, no matter how far these aggravating factors and the evidence swing you over to the death penalty side, can you promise me that you could listen and truly consider any evidence presented by the defense of mitigation before making your final decision?
Yes.
And again, mitigation is just simply evidence that of the defendant's background, of his life, of his character, that could cause you to feel that life is the proper punishment. Okay?
Okay.
So can you assure me that you can listen to the evidence, even if your pendulum is way over here on the death penalty side, you can consider that any mitigating evidence presented to you before you make a decision?
Yes.
Okay. Can you promise me you can do that even if at first blush something is told to you about a piece of mitigation evidence and your first thought is, I don't know if that's mitigation, I don't think that qualifies? Can you hold off judgment until you hear the details and all the evidence surrounding it to make your decision?
Yes.
Okay. Once you hear all the evidence of the aggravation and the mitigation in this case, then it comes to your decision of what the proper punishment should be. And that is an individual decision that you and all your other jurors individually have to make. Nothing ever requires you in the law to vote for the death penalty. Okay? You're not going to get a checklist that says if you're back there and you check these boxes off, you must vote for the death penalty. If after considering all the evidence and evaluating it, mulling it over in your mind, you felt that in this case, life in prison is the proper punishment in my heart, can you vote for that? Can you vote that life is the punishment?
Yes.
All right. On the flip side, if you find, and not a hypothetical situation, you're hanging out friends and talking in the abstract, a real life situation, if you're back there in the jury room and you're deliberating and you find, and you're mulling over all of the evidence and you determine in your heart that the death penalty is the appropriate sentence, you raise your hand and say, I vote for the death penalty, I vote that this man deserves to die for what he did.
Yes.
Any hesitation in your ability to do that, looking inside yourself?
No.
Is there anything in your life, your background, your belief system that makes you think maybe I'm not a good juror for this type of a case? I'm not saying there is, I'm just asking.
No, sir.
Okay. Thank you so much for your time, ma'am.
You're welcome.
No further questions, Your Honor.
Ms. Miller, you may inquire.
Hello.
Hi.
Let me ask you first, do you live in Orange County?
Yes, ma'am.
Okay. Work in Osceola right now?
Correct.
Okay. The insanity defense. I just have a couple clarifying questions.
Okay.
I think you can probably get where we're going, is that we are talking about the intentional, premeditated killing of a law enforcement officer. Defendant thought about it, meant to do it, and did it, without any legal justification, excuse, or defense, right? If somebody's found guilty. Okay, so we're considering now if that person has been proven not guilty by reason of insanity, okay?
Okay.
Not guilty by reason of insanity is still not guilty. We don't go to a penalty phase. The person's found not guilty. And so some people think that insanity is a cop-out or an excuse. Have you ever heard anything like that?
Not really.
Okay. But do you think you could find somebody not guilty by reason of insanity for the crime of murder of a law enforcement officer?
All right, can you?
Sure. The question is, do you think you could find somebody not guilty by reason of insanity? So that's somebody,
Okay.
let me break that down a little bit. If somebody's saying, I'm not guilty by reason of insanity, that person is saying, I did it. I was just insane at the time, so I'm not legally responsible.
Okay.
Does that make sense?
Yeah.
And so under those circumstances, some people say, for the crime of murder of a law enforcement officer, you would not be able to find that person not guilty by reason of insanity. Does that make sense? How do you feel?
I mean, if it's proven that they were not of the right mind at that time, then yeah, I would go with not guilty.
Okay.
With insanity.
Okay. And you, when the judge asked you about the murder of a police officer specifically, you said it would just depend upon the circumstances.
Correct.
Am I correct in assuming the circumstances you would want to know about are more about the circumstances of the crime?
Correct.
Would you want to know anything about the defendant's background?
Only going, toward the insanity part, but.
Okay, and that was a confusing question.
Yeah.
I apologize. Okay, so insanity is a narrow legal definition that the defendant is so mentally ill, diseased, infirmed, or defected that he couldn't understand the difference between right or wrong, or he couldn't make his behavior conform with the law. Okay, so you may hear about somebody having mental health issues and think, I don't think it's insanity, so I'm going to find him guilty. But it could still affect whether you think life or death is the appropriate penalty. Does that make sense?
Yes.
Would something like that, would you want to know about that?
Yes.
The state asked you some questions about mental illness, right?
Yeah.
And if you thought it was real, right? And you do, obviously.
Yes.
Same general question, different topic.
Okay.
Do you believe racism is real to the extent that someone who experiences the effects of it, it could affect the outcome or the direction of that person's life?
Do I think it's real in the world? Yes. Am I? No.
Not a racist?
No.
Got it. Got it. Was not asking that question, but I understand. Do you think you could give meaningful consideration, and when I say meaningful consideration, I mean you hear it, you internalize it, you process it, and it could affect the outcome as to whether you think life or death is the appropriate penalty. Doesn't have to, but it could, right? As opposed to some people say, yeah, I can meaningfully consider it, but they're hearing it, dismissing at the same time, and that's not meaningful consideration. You know what I mean?
Right.
So do you think you could give meaningful consideration to a defendant who's been convicted of murder, the effects of racism on that person?
Yes.
Okay. You probably won't be surprised to learn this. There are folks that have differing opinions on all of these things. Fair?
Fair, yes.
And that's okay. The law contemplates that. And that's why death is never required. Because if one juror thinks that the verdict should be life, the verdict should be life. Are you okay with that?
Yes.
Mitigation can be anything to anyone. It does not have to be unanimous, and it can be unique to each juror. And it's literally just why one juror would choose life or not choose death as the appropriate penalty. With me?
Yes.
Sometimes the aggravation can seem huge, right? The murder of a law enforcement officer. The defendant's been previously convicted of another murder. And the mitigation can be something like a smile that's observed between the defendant and a family member. And for that juror says, I saw that, and for me, I assign the weight of life to that. And I'm not giving a death sentence in this case, and that's okay. With me?
Yes.
For a just verdict to be returned in this case, all 12 jurors' individual moral assessments about whether Mr. Lloyd lives or dies have to be heard in this court. That's your duty, your right, and your responsibility. You're not going to bully or badger anybody to agree with you, right?
No.
Nor would you allow anybody to bully or badger you into changing your individual moral assessment.
Correct.
May I have just one moment, Your Honor?
Yes, ma'am. All right, either side need to approach?
No, Your Honor.
All right, ma'am. Let me take this off so you can hear me. We're going to send you through to the last round of questioning. That is the round where we will be picking the jury. So if you'll hand your badge to the deputy, please. The first thing that's going to happen is you are now a purple dot. The last group is purple. So when you call the number we're going to give you, you're listening for purple. and what day you're supposed to return. I don't know the exact date. It's going to be next week. It's not going to be this week. So call starting Friday after 5. You're going to hear a message that tells you when to report, okay? That day that you report, you need to have packed a suitcase because we're picking and sequestering the jury that day. So leave it in your car. You don't need to bring it in the courthouse. But if you get picked, we'll make arrangements for you to go get it. If not, obviously you're just driving home. There's a sequestration package in here, ma'am, that explains to you a little bit more about being sequestered and makes you, and kind of gives you a list of suggestions of things to bring.